H.K. Sharma, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant petition. Accordingly, the said petition stands closed on withdrawal. Interim order, if any, stands repeated. Hmm? Item number 10 to be listed after the two applications. What liberty?
The association has talents that on behalf of certain on board catering of now there with the talent period come full deposit money regarding for money for a period of serving money. So now we want to file a proper instruction for the amount they are entitled to, particular at this stage they are able to provide money.
Then
So
why are you going to file again?
so I'm instructed to withdraw my request.
Why is required? You can't withdraw. Today you are withdrawing again, you are filing it unnecessarily. This doesn't end the matter. What liberty? Liberty for what? If you can't produce it today, then are you thinking that after 10 years you are going to do it? Then yeah, go to item number 1 please. Okay. Here is the first item to be proposed. Huh? See, withdraw. Nampu Lily.
It's for
Go to book number 5, mention it there. Six. At the request of the learned counsel for the petition, and matter stands adjourned for to be listed after the puja. Yes, with the way. 1-6. The D. Gugoi appearing on behalf of the petitioner submits that he has been instructed by his clients that the writ petition that the writ petition has become infructuous and accordingly would not like to press the instant writ petition. Taking into account the above, the instant writ petition therefore stands closed on as it has been withdrawn. Interim order, if any, stands vacated.
I don't know what permission.
Yes. Ah, yeah. Maintainability. What are you asking for? Counterclaim was dismissed.
Thinking that it's for the delay of the proceeding.
Where is your application? Which is the order?
Order, it's number eight, it's number 51.
50.
Yes.
Yes, what is wrong with this?
I thought it was this.
No, your counterclaim was not dismissed.
What the claim? Stating that it was only for the delay of the property. I was not given a chance.
No. What was your petition? Here, what you are, today is the date, read the order of 9/1/2015 at page 50. You are challenging that order, wherein you wanted to bring in some Jatin Das as is the auction purchaser. Now the debt recovery tribunal said that no, you can't bring him. That's it. Why you are filing? Your counterclaim has to be against the bank.
So the options are really the-
So how does it have if your counterclaim is allowed vis-a-vis so and so, then it is a different thing. How can you bring here the auction purchaser? And why is this court entertaining these proceedings at all? Your counterclaim has not been dismissed. Look here, see the order. The counterclaim, when you wanted to bring in one Jatin Das, that has been dismissed. Then, and if you are aggrieved, why are you not approaching the DRAT? And by this, you have stayed. What has happened in, you are appearing, Mr. Khaniwar? You are for?
Correct.
Yes, now the proceedings have been stayed.
Paper.
Okay?
For the last one.
That's the case.
The thing is, how, property to get in the, in the very minimum of the transaction.
Huh?
They want to give the folder, my property to the.
Understood. But if you are able to prove it, that the auction purchase is wrong, matter ends. Why do you need him? You have to prove your own case. Why do you need him? He is only an auction purchaser which the bank has sold it. But be that as it may, why will this court entertain at all this matter under 226? Go into the DRT if you want it, but this can't be happen. Now, the instant petition has been filed challenging the order dated 9/1/2015 passed by the Learned Debt Recovery Tribunal Guwahati in OA number 187/2012 as well as OA number 38/2014 bracket CC. From a perusal of the said order dated 9/1/2015, it reveals that the petitioner, who was the counterclaimant, wanted to implead the respondent number 3, who is the auction purchaser, of the property which was sold by the State Bank of India. Kusto. The said application to implead the respondent number 3, as a party in the said application, said counterclaim filed by the petitioner was rejected by the impugned order dated 9/1/2015. This court had duly perused the impugned order dated 9/1/2015 on two grounds. Number one, this court is not exercising the appellate jurisdiction over the orders passed by the Learned Debt Recovery Tribunal. The jurisdiction so exercised by this court can only be done if the exercise of the power by the Learned Debt Recovery Tribunal is without jurisdiction or palpably erroneous on the face of the record. It is the opinion of the court that the rejection of the application, it is the opinion of this court that the order, impugned order dated 9/1/2015 is neither without jurisdiction nor is palpably erroneous, calling for interference of this court under Article 2 to 6 of the Constitution. The second reason, in the opinion of this court, is that the counterclaim is directed against a cause of action which is arisen between the petitioner and the respondent number 2, that is the State Bank of India. If the state counterclaim is allowed, the consequences would thereupon fall upon the effect of which could be felt by the State Bank of India. And the Learned Tribunal would be within its jurisdiction to pass consequential orders. Under such circumstances, it is also the opinion of this court that there is no illegality in the order dated 9/1/2015 passed by the Learned Debt Recovery Tribunal in rejecting to implead the auction purchaser, that is the respondent number 3, as a party to the counterclaim. Accordingly, the instant writ petition, being devoid of any merits, stands dismissed. The Learned Debt Recovery Tribunal, Guwahati, the interim order passed by this court stands vacated, and the Learned Debt Recovery Tribunal shall adjudicate the application, the original applications number 187/2012 and original application number 38/2014 (CC) on its merits.
Not to
Yes, Ms. Udas. Yes, what is this? What is he asking for?
They're asking for
How can this go court grant? Page. Amount determined by the competent authority and the so is accepted by the claimant. No objection was filed with the competent within the 21 days of stipulated provision under so. Now, question does not arise for further claim in the case. The compensation of the linear.
that page will be free.
Yes. Why are you before this court? No, understood. Why are you before this court? No, that I have seen. A plot of land measuring 3 kata 4 lesas have been acquired. The land was as kilometer pouring land. So if it is wrongly done, if it is wrongly done, can this court direct the competent authority to do so? No. Have you approached under section 3G5? So what? Arbitrary, there is a procedure. This is under the Land Acquisition Act, under the National Highways Act. So you need to approach under 3G5. Have you approached? Where? So, no. Deputy Commissioner is no. Where is that application? Let us see. Where have we approached? Yes, why have you not decided this? Where? Page 24. Who has decided? Let us see. Yes. He has decided this. 1/4/2014.
Yes.
Then
Then again, he approached the deputy.
No, thereafter you can't approach the deputy commissioner. After that, if it goes wrong, you have to move an appeal under 34. This has been rejected. How can this court exercise jurisdiction? Section 3G6. And National Highways Act condition. Why will this court at all exercise? It has been rejected your application. Thereafter, you are to prefer, you can't move this court subject to the provisions of the Arbitration and Conciliation Act shall apply to every arbitration under so and so. So you should have moved under 34. Period is gone. How can you entertain under 226 this is? These are not, this is specifically given out there. Like, oh, the instant writ petition has been filed by the petitioner. Seeking a direction upon the respondents to pay the compensation in respect to the acquired land at the rate of rupees 3,50,000 per bigha as Poringtoli/Poringoti homestead land instead, including entire plot of land measuring for 3 bighas 1 lesser in dark number 223, periodic patta number 145 of Gormai Kisam in Sohori Moza under the Raha Revenue Circle, Nagaon. It reveals from the records that the petitioner is the owner. The case of the petitioner herein is the petitioner that he is the owner in possession of 3 bighas 1 lesser of land covered by DAG number 223 of periodic patta number 145 of Gormarai Kisam in Sohori Moza under Roha Revenue Circle in the district of Nagaon, along with another plot of land measuring 1 bigha 1 katha 5 lessers covered by DAG number 51 under periodic patta number 146 of Dighaliati. Page number 6 of Lekha spelling. Dighaliati Kisam in the same Sohori Moza, Roha Revenue Circle in the district of Nagaon. For the purpose of construction of the national highway, a plot of land belonging to the petitioner at measuring 3 kathas 4 lechas of the first plot and 1 katha 6 lechas in the second plot were acquired. Thereupon, the competent authority passed an order under section 3G and the petitioner was paid a compensation of rupees 39,211. And 78,065. The petitioner thereupon being aggrieved, filed a writ petition before this court, which was registered and numbered as WPC number 719/2009. This court, by an order dated 13/3/2009, disposed of the said writ petition, thereby giving the liberty to the petitioner to approach to apply to the competent authority for the purpose of making a reference to arbitration in accordance with law. The petitioner thereupon filed an application under Section 3G5 of the National Highways Act 1956, seeking a reference to the arbitrator for determination of reasonable compensation. The said arbitration application was registered as arbitration case number 182/2009. By an order dated 1/4/2014, the learned arbitrator rejected the application, rejected the claim of the petitioner. Being aggrieved, the petitioner being aggrieved, the petitioner, instead of approaching the appropriate court in terms with Section 3G6 of the National Highways Act, again approached the competent authority by filing applications seeking enhancement. The said application have not been considered. The petitioner has therefore approached this court under Article 226 of the Constitution. I've heard the learned counsels for the parties. This court further finds it approach this court. Absolutely. This court further finds it relevant to take note of an affidavit filed by the wife of the petitioner on 7/6/2018. Wherein the instructions of the circle officer, Roha Revenue Circle, Nagaon, dated 4/1/2010 was enclosed. Next. This court has duly heard the learned counsel for the parties and perused the materials and report. The National Highway Act 1956 contains a stipulates a self-contained code for the purpose of determination of the compensation, as well as also the remedies to the claimants or the requiring authority. In terms of Section 3G of the National Highways Act 1956, the competent authority is required to determine the amount to be paid in terms with subsection 1 of Section 3G, keeping in mind subsection 7 of Section 3G of the Act of 1956. In terms with subsection 4 of Section 3G of the Act of 1956, subsection 5 of Section 3G, if the amount so determined by the competent authority under subsection 1 of Section 3G is inadequate, is not acceptable to either of the parties, the parties have a right to seek determination of the compensation by an arbitrator to be appointed by the central government. It is further seen that the arbitrator shall also be bound to determine the compensation in terms with subsection 7 of Section 3G of the Act of 1956. In the instant case, coming back to the facts involved in the instant case, it would be seen that on 1st of April 2014, the arbitrator had passed the award thereby rejecting the claim of the petitioner. The remedy to such proceedings, such award passed by the remedy to such award passed by the learned arbitrator can be seen from subsection 6 of Section 3G. Which stipulates that the provisions of the Arbitration and Conciliation Act 1996 shall apply to every arbitration under the Act. Therefore, the remedy which was available to the petitioner against the award passed by the learned arbitrator was for setting aside the award in terms with Section 34 of the Arbitration and Conciliation Act 1996. The petitioner, instead of approaching the appropriate court in that regard, has filed the instant petition. Taking into account that these aspects of the matter had approached this court, under Article 2 to 6 of the Constitution, it will setting aside have, on the other hand, approached this court after more than 2 years by filing the instant writ petition. It is the opinion of this court that such the filing of the instant writ petition is nothing but to circumvent the provisions of subsection 6 of section 3G of the National Highways Act, read with section 34 of the Arbitration and Conciliation Act 1996, and more particularly to subsection 3 of section which cannot be allowed to perpetuate, allowed to be perpetuated. Considering the above, this court doesn't find any merit in the instant writ petition for invoking the extraordinary jurisdiction under Article 2 to 6 of the Constitution, and accordingly the writ petition stands dismissed.
Number 3.
Who is they paying for? Guwahati Municipal Corporation officer on all these things. None appears. None has appeared on behalf of the petitioner on call. It reveals that the petitioner has not been represented on 6/6/2017 as well as also on 20/11/2020. It appears that the petitioner have lost interest in the writ petition, for which the writ petition stands dismissed for non-prosecution.
Number 4.
Yes, to recover the son of the petitioner, namely so and so, from the hands of the culprits who kidnapped by the accused person on so and remain untraced. Then,
In this regard, for the FIR has been lost for the and the FIR is been registered. Subsequently, the petitioner also submitted and representation before the SPO for the to recover the victim matter. But till then, the victim has not been recovered. And
then,
in the idea of the
now what do you want? What do you want? Your prayer is different.
Since the SC has not submitted by status report, so I prayed for a status report be filed by the.
Why are you bringing an affidavit in opposition filed by the respondent number 2?
Filed by the.
Under Secretary Revenue? Why is the Revenue and Disaster Management filing anything?
Because of the.
Or is it because of the council? Huh?
Prayer is there, madam.
Where?
Just 9, madam.
Where is there? For what?
Prayer just and irrigate compensation.
Where is it?
Phase 9 of my description, madam. Prayer.
Let us see. Where is it?
The rate of allowance must be issued directing the respondent to pay just and irrigate compensation to the central of commission terms in the event of non-compliance.
7 years is over.
Yes, madam. Incident took place, madam, 25/8/2015.
What do you want now?
Yes, madam, short time they will given to submit affidavit by the SPO, madam. number.
How did it happen?
My lord,
Let's see the Ejahat. That the informant begs to state that below noted person is my nephew.
father was the
The accused person is doing business by residing at so and so. The accused person called for my nephew. My nephew had not returned home till date and not found any clue. At night, he informed through telephone to home that he had been confined at Zolesor in the district. At this situation, I suspect the accused persons have been confined him at the area. Therefore, you are required to. What happened thereupon?
nothing.
Huh? What happened?
Satisfied of the evidence of SPH.
Why affidavit of SP or anybody is not there? Who is appearing?
For respond number 2, there is one.
Respond number 2, forget about respond number 2. Why the SP is not there? Why no instructions? What happened to the police case? Find it out at 2 o'clock.
Pilot, I have received instruction on that, it has been sent over the Dhubri police because my jurisdiction lies over my under the Dhubri PS.
Who sent? To whom it has been sent? Dhubri police station is only one police station. 2017 matter. Why have you sent to Dhubri? Where did your person get lost?
From hospital.
Who will be the officer who will be in charge of both Bhopata and Dhubri? No, who will be? Yes, Mr. Nath. You were appearing on the earlier occasion in this matter. Who will be the officer if it is both the districts? Who will be the officer who can say with authority something? Because the SP can't say more than what his district says. Who will be the person who can give us some detail, more information? Anybody? You see, the Director General of Police will be the main person, but who can give us anybody under him? Huh? AIGP. So I think we ask for an affidavit of the AIGP administration as regards the case. SP, the problem is that the SP Borpeta, if the matter is now being sent to Dhubri, how can the SP Borpeta who have it? Then who is going to file? So let the SP Dhubri bring it on record by way of an affidavit. Huh? Show me that instruction what you have. Then I will record it that it has been sent to Dhubri. Not Friday, but yeah, but I will ask them.
I want to submit one thing, my lord. FIR is, my lord, Golpara Dinar, Doleswar, Elakar, Prop, that is why, my lord, SP Dhubri has no any role. I think, my lord.
Anyways, we will record it.
That is why we can say. Let us
The instant petition has been filed by the petitioner, who claims to be the father. of the victim. Namely, Khondokor, Anisuzaman, spelling to Salivudi, page 13 or so. Khondokor and Aziz. It is seen from the records that an FIR was filed by the uncle of the victim, stating inter alia that the victim have been missing since 25/8/2015. The said FIR was filed before the officer in charge of Borpeta Khodor police station and was registered as Borpeta PS case number 2226/2015 under section 365 of the Indian Penal Code. The petitioner herein have sought for a direction for tracing out the victim by filing the instant writ petition. Prior to the filing of the instant writ petition, the petitioner had also approached the Superintendent of Police Borpeta on 24/9/2016, but to no avail. This court, by an order dated 28/4/2017, had issued notice, and there was a direction in that said order itself that the status report be called from the investigating officer as regards the progress made in the investigation in connection with the Borpeta PS case number 2226/2015. It, however, reveals that there has been no instructions received from the police officials since then. Today, when the matter has been called up, Ms. Udas, the learned additional senior government advocate, informed this court on the basis of an instruction issued by the officer in charge of Borpeta PS that the Borpeta PS case number 2226/2015 under section 365 have been transferred to Dhubri police station as per the order of the Chief Judicial Magistrate Borpeta on 7/6/2017, as the actual place of occurrence falls under Dhubri PS. The said instructions so submitted had been so placed before this court is kept on record and marked with the letter X. So, taking into account the above, this court directs whom? The Superintendent of Police Dhubri. No. This court had also inquired with Mr. Dina, the learned senior government advocate, as to how the grievance of the petitioner could be taken care of. More so when taken care of. Mr. Dina submitted that as per the instructions which have been kept on record will marked with the letter X, the Superintendent of Police Dhubri would be in a position to give details as regards the investigation. Taking into account the above, this court fixes the matter again on 6th of October 2023. The Superintendent of Police Dhubri is directed to file an affidavit on or before 4th of October 2023, bringing on record the status of Borpeta PS case number 2226/2015, which have been transferred to the Dhubri police station as intimated to, as informed to this court by the communication and kept on record, which has been kept on record with and marked with the letter X. A copy of this order be furnished to Mr. D. Nath for effective compliance. Senior Government Advocate. Huh? From the consistent petitioner had submitted a petition for the mercy of the maid servant, namely the duly recorded. The instant writ petition was filed by the petition. Instant writ petition is filed by the petitioner seeking a direction commanding the respondents to recover the victim woman and arrange recording of her statement before a magistrate and to take action against the accused persons on the basis of the FIR dated 9/1/2017 lodged by the petitioner with the respondent number 4. Upon the instant writ petition being filed, this court, by an order dated 9/6/2017, issued notice. The record reveals that an affidavit in opposition was filed by the Deputy Commissioner of Police, (Crime, Guwahati). In the said affidavit in opposition, it was mentioned that on 6/12/2016, the petitioner had submitted a petition about the missing of his maidservant, namely Hasina Begum. The information was duly recorded by Dispute PS GDE number 536 dated 6/12/2016. During investigation, the inquiry officer sent WT message to officer in charge Bilasipara Police Station with a request for causing inquiry and to recover the victim, Hasina Begum, and to apprehend the accused, Hassan Ali. Subsequently, the FIR dated 9/1/2017 submitted by the petitioner was received by the officer in charge Dispute Police Station. And based on the said FIR, a case under section 366/376 of the IPC was registered as Dispute PS case number 73/2017. It is also mentioned in the said affidavit that the victim woman was recovered from Bishnupot, Korumotoria, Mathura Nagar under Dispute Police Station on the basis of interrogation of the accused Hassan Ali. and produced before the court on 21/8/2017 for recording her statement judicially. Taking into account the said stand in the affidavit filed by the respondent number 3, nothing survives in the instant writ petition, for which the writ petition stands closed. Mr. Huh? Your name? Esnath. Mr. Esnath, the learned counsel appearing on behalf of the petitioner submits that the writ petition has become infructuous and as such would not like to press the instant writ petition. In that view of the matter, the instant writ petition stands closed. More order import সমস্যা নামটা বেলেগকে দিব I didn't mention the last part. এরকম নামগুলো এরকম লিস্টে পেপার মধ্যে দিব। Yes, what is this? Huh? Why? What is there? Let us see what is there. Restraining to construct the school building in the land of the petitioner white so and so under remand on director to dispose of the representation filed by the petitioner after proper inquiry. Yes, you are constructing on his land.
I am private customer, madam.
Who are you?
I am standing counsel elementary.
Standing counsel?
Elementary. For respondent number 1,
Who is constructing?
madam, respondent number 8. That's what.
Who is appearing for respondent number 8? What is that school? What school you are constructing? What?
I am under the I am paid.
Yes.
20 last year, I have contacted several times with the headmaster, number 8. But till date, they were
Yes, where is your senior? Where? Fantastic. Ask him to come. This is a case for dismissal. Yes. Next. 9. Yes, what is this?
This matter of
Infructuous.
the matter last listed in the year 2021.
What is this matter about?
This matter is pertaining to 250 shops which are in the Quran.
Shift their market to open space available in front of the inspection bungalow. Have you given them?
My lord, that supermarket that was proposed to be constructed, that project has been foreclosed as per my last reference, the year 2018.
2000? Tell me, show me. Does not arise.
Does not arise, my lord, considering the fact that the project has not been. But it doesn't want to proceed.
The instant writ petition was filed by the petitioner. On the basis that the petitioners petitioner would be out of business in view of the NLCPR project bracket construction of supermarket complex at Moran. And as such have sought for and as such had requested the various officials the temporary arrangement be made of the Moran Doinik Bazaar in the open space available in front of the inspection bungalow. Mr. P. Hendik, the learned counsel for the PNRD department submits on instruction that the NLCPR project bracket construction of supermarket complex at Moran have been foreclosed. As would be apparent from the communication issued by the Undersecretary to the Government of Assam, PW Building and NH bracket DEV-B bracket close department dated 29/11/2018. The said instruction have been placed on record by Mr. P. Hendik. The said communication being produced before this court is kept on record and marked with the letter X. Under such circumstances, as the construction of the supermarket complex at Moran have already been foreclosed, the question of granting the petitioner any temporary rehabilitation does not arise. Accordingly, the instant writ petition stands closed as it had become infructuous. Interim order, if any, stands vacated. Eleven. Yes, madam. Oh. Learned counsel appearing on behalf of the petitioner, madam. What is your name?
Yes.
Bidas. Submits that the writ petition had become infructuous. Accordingly, the instant writ petition stands closed as it has become infructuous.
Well,
Yes.
that admit,
What is that?
I was directed by them for that.
The last order says that some further time is required. Yes, what is this affidavit business? Let us see.
This is regarding blocking construction of a train to the Patta line.
Why should not be prohibited, commanded, restrained from digging out any drain in any manner over the land of the petitioners? Who is digging?
PNC lost the train.
Yes.
This matter has been solved. The residents are written to the that they do not want getting drain to the Patta line of the.
Then,
Which I was.
Mr. Roy, you are appearing or you are without gown? Okay, you are petitioner in person. Okay, now tell me, what is there? Yes, Mr. Bora, what is there? Anything? You have stopped digging the drain yet?
There is a stay order.
Huh?
There is a stay order.
The stay order is temporary. What is the permanent thing to be done? You are not going to make any drain in their land.
At present, there is no.
You are not going to do that. PWD is a party and PWD is not represented. Who is response number 4? That is old. PWD is not a, but it is a. There is an existing drain flowing from the eastern side of Yasin to overcome the waterlogging problem of Torun Nagar Island number 1. Fresh notified proposal was prepared by we are submitted by the to the state government. Any contribution from drain. No, is the Mr. Bora, is the drain outside the land or inside? You have filed an affidavit. What does it say? Page number 2.
6.
Page number 2. Yes. Where is the drain? Hindustan Kendriya Vidyalaya. It is inside their land. Huh? Huh.
That drain is the internal drain of the school lot. Now they want to construct it in such a manner that plot will be divided in 2 parts. If the plot will be divided into 2 parts.
You want to do it in between?
Go around the page number
7.
7. That
Yes,
is the
where is it?
diagram. It will give by the
Where are you proposing?
It will go to the border of the.
Nothing will be to reduce my affidavit in reply. Where
Will let us see from this map. Just tell me where.
What will see GS road
Ah,
from the EDC point.
yes.
There is a dot line that the train will connect, then it will see the left turn, then again left turn. Right turn, then left turn, it will join the main train. Then it will follow to Bolu.
So you are not going to bifurcate their land.
Then it will be perfected on the border of the particular land,
Border or inside?
from the border. But no, I think
There's a difference. A border may be inside or outside.
maybe part of the Patal land may be.
entire Patta land lot, not part.
Huh?
It is admitted fact lot. You have
No,
not-
no, I mean, Mr. Roy, kindly come to this annexure B, page 7.
Of the affidavit in open.
Page 7.
But the school has been thrown in communicated.
This is Hindustan Kendriya Vidyalaya.
Yes.
Now this is the drain which is going.
No, there is no drain lordship. This is the internal drain of the school. There is a boundary wall of 6 feet height lordship. There
So,
are-
so they want to put this inside your drain.
Yes,
Put this, the
They want-
entire water flow would be inside your land.
inside your land lordship and here your lordship will see this may show that the entire land will be divided into 2 parts.
How,
The affiliation by your lordship,
how 2 parts?
2 parts lordship, where it will be decided there is a.
No, your land, this is Torun Nagar Masjid, and then backside is your land.
Yes.
Okay, then this is the water flow which goes and then it takes a right and then left and then falls into that thing.
Lordship, there is no drain, the drain is of the school.
Understood? I duly understand that what they are trying to do, they are trying to use your drain for the outflow of the water from outside.
From outside Lordship by breaking our boundary wall law. By breaking our boundary wall law. My lord, I have filed an additional affidavit.
So, you have a copy of it. Give it to me. If you have an additional,
Filing.
I have not been signed.
you don't have a copy.
No, because
What did you want to say? You are the petitioner in person.
Yes.
What do you want to say from the additional affidavit?
we want to-
Let us hear from you. You are the person who signed it.
Lordship,
And we have the advantage. Earlier, you may say that my client says something. Now you are going to say by yourself. Now tell me, what do you have to say?
May you please to take up my affidavit in this line.
Yes. Tell me.
The different reply that it's 7/12.
Hmm.
Lordship will come to the page 6 of corrected one.
Page 6. Ah, got it. Yes.
Yes. So Lordship, on the request.
We are the resident of Torun Nagar by lane number 1, beg to state that we are very grateful the Iman for sanctioning the Pakka drain through the premises of Iman to drain out the sewage water for Torun Nagar by lane. But as there was a legal issue regarding the land so we residents have approached the school and requested them to construct the drain from their end through the school premises so the water flow without affecting the school students, and they have agreed to do. In this regard, we request you not to construct there. So this would not help it otherwise. Because they are going to, they may not, because they are, it is for them to decide. Now tell me, how are you going to have it inside their land? Because if there is an overflow of the water, it will flood out. Even assuming this is the annexure B is the drawing. If there is an overflow of the water from JS Road and it goes there, and then it will go towards Masjid and then it will go to their land. It is this is inside the drain, is inside their premises.
That will be the drain and it's also the wall, already.
Understood? But then also if you allow that, all this water will also go to his place also.
So our school is situated just by the side of an another. It is highly flooded area.
In the way, better by the already.
Only there in between school and another, there is borrowed.
That will fall in the border.
Lordship, Tarunnagar by number has connection up to the Horolu River, but they are not touching that road. Tarunnagar by they are not digging out any drain. They want to damage the land of the British Lord, which is a Pakka land. It is a bit of fact, Lordship.
Acquire that land.
Okay, respect, right?
You acquire that land. So you don't do anything without acquiring that land. Huh? So, anything else? Without acquiring your land, they cannot. So they will acquire your land if they want. If they don't, they let them do it.
Consider that on the request of the residents of the Tarunnagar by land number 1. The EMC has taken decision to dig out a drain to our school. Now they have informed to the commissioner that they do not want, but the problem has been solved. The next one, Lord.
If the problem is solved, then why you are not withdrawing the requisition? If the problem is solved.
Then it's all Lordship. There will be an order from the court of the.
Huh?
That will protect the petitioner.
You are always there in the court, you can again come back. If the problem is solved, why do you need to again? What is the problem?
Then are also case to dispose of.
Dispose of as what?
That they without petition something like they cannot.
The instant writ petition has been filed by the petitioners. Challenging the actions of the respondents. Guwahati Municipal Corporation as well as the Public Works Department in taking steps in proposing to take steps to dig out a drain in the land belonging to the petitioner. A public drain in the land belonging to the petitioner. A perusal of the instant writ petition reveals that the petitioner number 1 is the owner of a plot of land measuring 4 bighas, 2 kathas, covered by KP Patta number 1119, Dag number 2013, 2121, 2196, and 2220 of village number 2, Japorigo, under Moza Beltola. Upon the said land, there is a school known as the Hindustani Kendriya Vidyalaya. On 19/4/2018, an assistant engineer of the PWD Roads Division number 1 had come to the school campus of the petitioners and met the principal and told the principal that he had been assigned the work to dig out a drain over the Patta land of the petitioners for taking the rainwater, waste, latrine, bathroom, and kitchen water of Tarunnagar Byline number 1, to which the petitioners objected. It has been also mentioned that the PWD, JMC, JMDA, and the DC, Kamrup Metro, had prepared a plan for digging out the drain over the Patta land of the petitioners to take waste and rainy water of Tarunnagar Byline number 1. But till date, no notice have been issued by the state governments to the petitioner. Under such circumstances, the petitioner had also lodged an FIR before the Bhangagar police station on 24/2018 and sent copies of the said FIR to and also represented before the chief engineer PWD, Mayor GMC, Commissioner GMC, DGP Assam, as well as to the chief minister, as well as to the minister of the Guwahati Development Department. However, the respondent authorities have not given any heed to the representation so submitted. And as such, the instant petition was filed by the petitioner. on 22/5/2018. This court, by an order 3/5/2018, issued notice and directed, and in the interim directed that till the returnable date, no construction of the drain shall be carried out over the patta land of the petitioner. It was also made clear that the said order would not come in the way of the GMC authorities to clean any existing public drain without disturbing the possession of the petitioner over the patta land. The said interim order have been extended from time to time and is presently still in force. The record reveals that the respondent number 4 had filed an affidavit in opposition. The affidavit, in the said affidavit in opposition, it was mentioned that there is an existing drain flowing by the eastern side of Hindustan Kendriya Vidyalaya since long. In order to overcome the waterlogging problem of Torunnagar Bylane number 1, a fresh modified proposal was prepared by the state PWD as per the proposal submitted by the Guwahati Municipal Corporation to the state government over the existing drain. It was also mentioned that there was no conspiracy to dig out a drain over the patta land of the petitioner, but it is a modification of the existing drain which was there since long for proper drainage of the rainy water. It was also mentioned that as the modified drain will be an RCC1, as such there will be no obnoxious smell. It was stated that authorities are going to modify the existing drain by making it RCC1, which is flowing by the eastern side of the Hindustan Kendriya Vidyalaya since long. Further to that, it was also mentioned that the Torunnagar Bylane number 1 is adjacent to the side of Rajiv Bhavan near ABC. This area has 50 families residing since long. As the JS Road side level is higher, the drain oblique water, the drain oblique waste oblique rainwater are flowing through a natural drain by the side of the lane of Torunnagar Masjid and Hindustani Kendriya Vidyalaya up to river Bhorolu via Dinesh Oza Pot. It has been mentioned that this is the one and only outlet of the drain water of that locality. But it is, look at it. First, it was stated that the cross section of the drain by the side of Masjid and Kendriya Vidyalaya compound wall is much smaller than the required size. Therefore, a regular water logging is occurred at Torunnagar Bylane number 1. In order to mitigate the said artificial flood, the Guwahati Municipal Corporation suggested reconstruction of the drain with proper size under the Mission Flood Free project. According to the said proposal, PWD City Division 1 had taken up the construction work of reconstruction. To the said affidavit in opposition, To the said affidavit in opposition, there are two annexures, Annexure A and Annexure B. A perusal of Annexure B reveals the schematic map of Torun Nagar Bylane number 1 and the inner drain by the side of Torun Nagar Masjid and Hindustan Kendriya Vidyalaya up to Ghorolu River via Dinesh Oja Path. The petitioner thereupon filed an affidavit in reply. In the same affidavit in reply, it was mentioned that on the eastern side of the land of the Hindustan Kendriya Vidyalaya School, Kendriya Vidyalaya, there is a private drain of the school on its own patta land, touching the boundary wall of the school. And the respondents cannot claim it to be a public drain. It was further mentioned that the GMC authority or other officials have no right to dig up the drain dividing the school plot into two parts, which is not permissible as per the CBSE affiliation bylaws. And if the school plot will be divided into two parts, the CBSE will cancel the affiliation of the school as per the affiliation bylaw. Further to that, it would cause environmental and air pollution, as because after the boundary wall of the school on both sides of the Torun Nagar Bylane number 1, there are more than 100 residential houses of the residents of Torun Nagar Bylane number 1. And in that event, all the latrine water, wash water, bathroom water, kitchen water, and rainwater of both sides of Torun Nagar Bylane number 1 will pass through the school campus, which will cause nuisance, and school campus will be flooded, and the latrine water, wash water, bath water, bathroom water, kitchen water, and rainwater of about 100 numbers of households of Torun Nagar Bylane number 1 would spread over the patta land of the petitioner, causing inside the school campus unhealthy hazard situation to the students of the school, teachers of the school, guardian, and members of the school managing committee. It is also mentioned that the residents of Torun Nagar Bylane number 1 had also requested the GMC and the executive engineer PWD-R not to construct any drain over the school land. The claim of the GMC that there is a natural drain through the school campus is baseless, incorrect, and false. This court have also taken note of Annexure 1 to the said affidavit in reply. And from a perusal thereof, it is seen that 7 persons have requested the Commissioner, Guwahati Municipal Corporation, as well as the Executive Engineer PWD Roads, that not to construct the drain through the school premises, but to construct the drain at Torun Nagar Bylane number 1, where there is no pakka drain. So I've heard the learned counsels for the parties. I've heard the learned counsel for the petitioner as well as the counsels appearing on behalf of the GMC. The PWD department of the government of Assam have neither filed any affidavit nor is represented before this court. From a perusal of the writ petition, from a perusal of the pleadings and the documents enclosed therewith, it is clear that the petitioners, it is clear that the respondent authorities are taking certain steps for the purpose of tackling the artificial floods in the Tarunnagar area. From Annexure 2, Annexure B to the affidavit filed by the respondent GMC, it reveals that the respondent authorities have planned to divert the rainwater from the Tarunnagar byline number 1 through the Tarunnagar Masjid to by the side of Tarunnagar Masjid, and thereby using and then to the drain to the Dinesh Oja Pot by using the private drain belonging to the petitioner's school. It is the opinion of this court that the respondent authorities cannot, in the name of tackling the floods, artificial floods, use the private drain of the petitioners. In as much as that would amount to infraction of the petitioner's rights under Article 300A of the Constitution. As well as also (300A) of the Constitution. Under such circumstances, it is the responding authorities, if they want to, this court is of the opinion that if the responding authority wants to use the land belonging to the petitioner, such land has to be acquired by following the due process. wants to use the petitioner's land, or you even they use the private drain of the petitioner, the same has to be done by following the due process. Under such circumstances, this court is of the opinion that the apprehension of the petitioner, as has been raised in the writ petition, is a justified apprehension, more so taking into account the affidavit filed by respondent number 4. This court therefore disposes of the instant writ petition, directing the respondents from digging out any drain over the land of the petition, or even using the private drain of the petitions to drain out the water, unless the land or the drain or the right to use the private drain have been acquired by the respondent authorities by following the due process. With the above, the petition stands. Yeah. Who is making the construction? Who is the authority of this? So it's a private dispute. No instructions. The instant petition has been filed by the petitioner. Taking a direction upon the respondents not to construct the school building in the land belonging to the petition. It reveals from the records that this court, by an order dated 19/6/2017, issued notice, and in the interim directed all the respondent authorities not to undertake any construction of the school building over any portion of the land belonging to the petitioners. This court had the learned counsel appearing on behalf of the petitioner at the outset submits that the school which was proposed to be set up in the land of the petitioner is no longer, has already been, the said proposal has been abandoned, and the school would be set up in some other locality. However, the private respondents number 8, 9, and 10 are in occupation of the petitioner's land. Taking into account the above, the learned counsel for the petitioner had submitted that he would not like to press the instant writ petition, as the respondent authorities are no longer involved. Rather, the petitioner would resort to such remedies available before the competent civil court against the private respondent number 8, 9, and 10. Taking into account the above submissions made by the learned counsel for the petitioner, the petition stands closed on withdrawal. The withdrawal of the instant writ petition shall not affect or prejudice the rights of the petitioner to avail such remedies under the before the competent civil court against the private respondents. The interim order stands beginning. Yes, madam. Very good. What is this matter about?
Dated 15/11/2017. Says that he is not an agricultural law.
Where is that 1511? Page number?
7/9.
Yes, what are you assailing? It's a non-agricultural produce. Then
The tea leaf cannot be consumed raw. So it is processed and then consumed. So the clarification was regarding. So if you go by point of the three, they say that tea used for making the preparate such as black tea, green tea, white tea, the processed product. Which they do not consider tea as an agricultural.
so what is the effect if it is not an agricultural produce?
But not very.
Under? From whom?
Which is the petitioner is engaged in business of providing services of warehousing to this people. And before this notification was, before 2012, we were exempted from paying out service tax. But from, and after 2012, we were included in the negative. But, clarification. 2017 and because of which, we have, they are not providing us with further.
You're not getting the exemption. Then so how is meat tea an agricultural produce? Why? You can't have green tea leaves raw, can you? Then it has to be processed.
Additional activities that, green leaf are agriculture produce, but the seed when it gets processed processed for consumption, that is not an agriculture. As, in our reply, we have said that since green tea cannot be consumed, that's why they are processed so that it is available for consumption of green.
Now, whether sugar is agricultural produce, it's made out of sugar cane. No? Is it an agricultural produce? What is your basis to say that made tea is agricultural produce?
They say that
Forget about they, you. You are before this court. Why do you say so?
production before included in agriculture, even now it is included in the negative. But as agriculture, it comes under agriculture.
Show me that. Where is it?
But
Fruit juice. Fruit juice. Agricultural produce. Why? Tea, made tea is also processed.
but it cannot be consumed. If the green leaf, it is not in a position.
So if it cannot be consumed, can that be the test of agricultural produce? What is an agricultural produce? There must be something. When you are saying so, there has to be something. Page number? Okay. Agricultural produce means produce out of cultivation of plants and rearing of all life forms of animals except rearing of horses for food, fiber, fuel, raw material or others, on which either no further processing is done or such processing is done as is usually done by a cultivator or producer, which does not alter the essential characteristics, but it is marketable for the primary. So, rice. Rice is an agricultural produce. Or the grain. Or the paddy. Tell me. Not prepared? Why? Because she said that she will take an atonement. Huh? Yes, what affidavit who has filed? Reply saying what?
reply to the application of the petition
What do you say out there?
that,
It's agricultural. What is your basis that you don't? The clients knows.
Being tea leaves, they say is an agriculture, but they don't consider tea as an agriculture. But green tea leaves cannot be consumed as raw. It has to be dried and rolled to make it consumable for food.
So the moment we say that, this is tea warehousing. Are you going to say that this is not a manufacture? Tea doesn't, from raw tea, the tea leaves to process tea is not a manufacture.
If we do not do that, it cannot be consumed.
Forget about the consumption. The agricultural produce definition does not say anything about consumption. It is only on the question of marketability. Just for example, you cannot have a paddy, but the paddy has to be removed. And for removing it and then placing it out there would come within the ambit of agriculture. But it does not lose the essential characteristics. Because if we are to accept what you say, wouldn't that affect all the companies who are getting benefits under the central excise scheme or GST exemptions and all, and holding that it is not a manufacture? Because if I allow this petition, there will be a huge problem for those people. No answer. The learned counsel appearing on behalf of the GST. GST submits that the affidavit in reply has been received only today. Taking into account the above, this is the matter after the puja vacations. Yes.
Application 8/4/2019. Get lots of time to file it.
What did you submit? To initiate appropriate action against the respondent number 4 on the complaint filed by the petitioner. Who is respondent number 4?
And his name as it cut off, he was the Lakpanda by name. And now the number 4 is the Lakpanda.
Then you are against the office of the or the person.
Upon the conduct of person, he did not demarcate the name.
Understood. So you are against the person or the office?
Now we have because he seems he has
Uh,
by order dated 22nd of.
Now, has the demarcation happened?
No, that's my inspection.
Why the demarcation is not been done?
Whether in the affidavit opposition or not.
Here it has been mentioned the demarcation is done at paragraph number 5.
Yes,
Then what remains?
no matter. But that's why there is two annexure B.
Annexure?
Okay.
Yes. Annexure D, there is no annexure D. B. Yes, today on so and so, the schedule of land in respect has been shown by the petitioner as per their petition. It is hereby noted that part of so and so could not be shown as the land was under Azmali, signing by so and so.
mistakes. So I say the 86, 87.
You are the owner of what land?
I am the owner of 86, flat number 86, 87, 88, 84, 83, and 94.
Huh? It's a Ismaili land.
Then land, then 18 acres, 201.
What happened to your suit?
It was withdrawn.
Then why you not? There are some other people who are in occupation of your land. Why do you need the demarcation then? Why you not filing the suit?
But those people we are not aware who are they. That is why the suit was withdrawn. In fact, we filed the suit against some person. And subsequently, we came to know they have already left the suit.
Then
Then we went to withdraw the
who
suit.
for land grabbing?
But in fact, the lordship pending came up to page 14 of the petition. There the DC was asked to enter into the method. But
But that can't be done because the name of the respondent number 4 have been struck off.
it was directed to the deputy commissioner.
Understood, but can this court now do anything, taking into account that the name of the respondent number 4 has been struck off?
But that is the deputy commissioner.
For against whom? Against the respondent number 4, his name has been struck off by an order passed by this court.
That is by petition and it's also by the.
What? How can the petition be disposed of in that manner? Annexure?
Annexure A.
Yes. Application for taking action against the lot mandal. You can't. This court is not going to do that because this is personal to him and his name has been struck off. Then the land has been shown to you. Yes, your land falls out here, but if the question of them demarcating does not arise now because there is some encroachers out there. How can they demarcate? You are to file a suit. This is the only way out. All land grabbing. The legal counsel appearing on behalf of the petitioner submits that that taking into account that there are encroachers upon the land of the belonging to the petitioners. The relief which has been sought for by way of the instant petition cannot be availed. The Land Council, however, submits that the withdrawal of the instant petition should not affect the rights of the petitioner to approach the appropriate forum for the purpose of eviction of those encroachers. Taking into account the above, the instant petition stands closed on withdrawal. However, the withdrawal of the instant petition shall not preclude the petitioner to take appropriate action as permissible under law against the encroachers. against the alleged encroachers over the lands belonging to the petitioner. Yes,
Chhatrapati non-payment of the awarded amount by the DRB, madam, District Resolution Board. Madam, page 98,
who has not paid?
madam, PW.
PWD is not represented nowadays. They don't care about anything. How much amount?
Madam, it was 82 lakhs, it was 82 lakhs 64,000, out of which, madam, 62 lakhs 94,000 had been paid on 2017-2020, madam,
You've got
2020. Remaining amount of, madam, 18 lakhs 51,295. Is left, madam.
Let us see what is this order.
Madam,
This order, how has this order come into being?
madam, this was after the order passed by the.
Of the award by the Dispute Review Board consisting of the presiding officer Swain.
Was this honorable court, and this honorable court by order.
Where is the amount, total amount mentioned?
In my pleading at page 13, madam.
No, in the award,
Award, madam, the total has not been mentioned, it has been segregated by different claims here, starting from page 91,
claims of the claimant.
starting from page 91, madam, in number 18.
Bank guarantee valid up to has become defunct due to the inaction and therefore the DRB do not feel to pass any direction. Release of security is directed 12 lakhs. Release of payments. Compensation for delayed payment of the account. How is the DRB constituted?
Madam, the clause 25,
Of
of the contract agreement at page 27, madam,
27.
of 25. So then after, madam, order of the honorable court. We have taken lots of.
The contractor believed that the decision taken by was outside the procedure. The dispute winner shall be considered with Swain. And be paid daily at the rate of specified days. Okay, so this has been done under 25(1) and 25(2), and they did not appeal, do any arbitration. So this amount is admitted. How much did you get
Madam, 62 lakhs 94,470.
out of?
I can mention.
Is there any interest?
Madam, 9% from after 56 days of the award. If they don't pay within the 56 days, that is at 8 lakhs.
82 lakhs was the claim when you filed,
Madam,
and out of that, how much you have got,
Madam, 62 lakhs 94,470.
and how much amount you are going to get now,
Madam, 20 lakhs 61,490.
as on today?
Madam, no, except interest, madam. Except interest, only the awarded amount. I'm not calculating the interest.
Are you going to have the interest on the amount of which is left on the principal
So on the left,
without taking into account of the interest on the principal as it stood prior to that?
no, madam, on the total amount, but we have got the 62 lakhs at page 107, madam, you see on.
82 lakhs is the amount.
Madam, awarded.
There is a direction to pay the interest
Yes, madam.
at the rate of 9%
9%.
from the date of 60 days.
Madam. 56 days.
Huh?
56 days.
56 days. Then what happened? When did you file the writ petition?
And the resolution was filed on 21/5/2018.
And when was the award passed? Yes, why you are not paying? Then
remaining amount can be paid, you can represent before the authority by the remaining amount. That can be paid within a stipulated period.
Why are you going to represent?
I mean, where the total amount including the interest from the remaining amount.
Why are you going to represent with them any further when there is already an award in your favor? When this court is in session of the matter, why do you want to represent before them? You want to give them some advantage?
No,
Huh? Or you want to withdraw, withdraw.
no,
But this court is not going to give these type of orders of consideration.
Right.
We can have it before some other bench. They may give you, not this court. Okay, list it before any other court.
no, madam.
No, yes. Why should I take? You get this type of orders before any other. Court. Yeah, next. This is the matter before any other. Where? No, I'm not taking up the matter, so why should I? Yes, what is this matter? Who? S. Sharma? Yeah, what happened to him? No. At the request of the counsel for the petitioner, Mr. M. Sharma, who is not well. At the request of the, it has been informed to this court that Mr. M. Sharma, the counsel appearing on behalf of the Central Bank of India, is not well. List the matters on after publications. What law? Okay, we listed on 8th of December. 6th of December.
19.
Yes, what do you have to say? Who is paying for revenue? PWD gave the approval. So you have to pay. Why? Every time a change of a council, earlier Mr. R. Babujari was appearing, now you are appearing. Every time there should be a change. This matter has been, the only reason why you have not paid them, that 31% or something, huh? Don't tell me about your senior. You are entitled to some 7,61,000 if I am not wrong. That is the amount which you have done of 31% or something. So here, on the last occasion when the matter came up, the only objection the revenue had that there was no approval. So he showed up, Mr. M.H. Amit M. Hussain. So that no, there is an approval. So this court had directed the authorities to get it, and Mr. R. Dhar, appearing on behalf of the PWD, categorically says that yes, there was an approval for which I have kept on record a document marked as annexure letter X. So there is an approval by the PWD for construction of the circle officers' quarters. Give them the bricks back. Do you want to demolish it? Give the bricks back to him if you are not willing to pay. Every time this is going on, every time this matter has been lying out here every time. You see, after 2019, the matter came up on 9/8/2023. When for revenue, Mrs. P.R. Mohanto appeared and apprised as to any further development in the matter. Then Mr. Arbor Pujari appeared on 38/2023 when he said that there is no approval.
Okay.
Then the matter came up, this court directed the what is called PWD to get the approval on 11/9/2023. He said that yes, the PWD had given the approval. And as such, you are liable to pay that amount, 7,61,000 or what? What is the amount?
It was 25 lakhs.
7,11,000. No, 7,11,000. That is the only amount he's done. He has only done 30% of the work or something. So remember, this is the only work he has done, 30%. Yes. Physical progress achieved is 31% of the financial liability on this date is 7,11,000. Payment could not be made to the on account of lack of funds. This has been written by the Chief Engineer PWD on to the Deputy Commissioner. Then what is happening is Under Secretary to the government says the requirement of funds. Everything is going on. I could have disposed it on that day, but the problem was the PWD was saying that no, the revenue was saying that there is no approval. There is some affidavit by the revenue.
Yes, the kind of 13 by 40.
Regarding the requirement, the demand was requested by the to clarify, but no response is. Para 13, where we got to the answer in the police state that so and so, the administrative approval of the year for an approval was accorded by the government of so and so, so and so. Accordingly, work was undertaken by Iman and the revenue and revenue was not communicated about it. Till date, no instruction in this regard have been received by the revenue and disaster, and there is no record of any administrative approval as such. Therefore, payment of any amount by the petitioner and the result does not arise. And the administrative approval is at running page 39. Under Secretary to the Government of Assam, PWD Department, administrative approval and the financial sanction of fund for construction of the Circle Officers Fund, Assam, type so and so at Bilasipara. It is there. And this has also been categorically mentioned on last date by the Chief Engineer PWD. With reference, I have the honor to inform you that AA admin was accorded for the construction of so and so by the PWD by serial number 1, which is authenticated. Yeah. We dispose of directing you to pay whoever it is. Who is to pay? Deputy Commissioner or who? Who is going to pay? PWD.
So this is accorded by PWD. They will pay.
Administrative approval, you have to pay. The instant writ petition has been filed by the petitioner, seeking a direction upon the responding authorities to release the outstanding amount of rupees 7,11,700 to the petitioner along with interest. It reveals from the records that pursuant to an invitation for bids dated 11/1/2011 issued for construction of the Circle Officers Assam type quarter, deep tube well, boundary wall, etc. at Bilasipara Revenue Circle by the Superintending Engineer, PWD, Guwahati Building Circle number 1. The petitioner participated in the said contract and was issued a letter of acceptance dated 23/2/2011 at a tendered value of rupees 23,79,629. The petitioner had also submitted a performance security of rupees 1,19,000. It further reveals that the petitioner started the work in question on the basis of a notice to proceed with the work dated 25/2/2011 and had submitted a running bill amount of rupees 7,11,700. The respondent authorities thereafter measured the work and gave the completion certificate. However, the said amount was not released. No, first, the running bill of 7 lakhs. First, it is also relevant, revealed from the records. The respondent number 4, that is the executive engineer PWD Dhubri Building Division, had written a letter to the superintendent engineer PWD, submitting the demand for the fund for the work of the circle officer quarter at Bilasipara Revenue Circle. Along with the said letter, an utilization certificate, the completion certificate for an amount of rupees 7,11,700 was also submitted. However, the said bill remained unpaid and overdue, for which the petitioner had to abandon his work. The petitioner thereupon had been pursuing with the respondent authorities for payment of the amount of rupees 7,11,700. But the respondent authorities have not paid the said amount, for which the instant petition was filed for a direction upon the respondent authorities to pay the amount of 7,11,700 to the petitioner along with the interest. It reveals from the records that the respondent number 6, that is the Secretary to the Government of Assam Revenue and Disaster Management Department, had filed an affidavit on 14/3/2019, wherein it has been mentioned that as per the report of the Deputy Commissioner Dhubri, the work relating to construction of the Assam type quarter, deep tubewell, boundary wall, etc. of Bilasipara Revenue Circle office was executed under the executive engineer PWD B Dhubri under the scheme of Assam Vikas Yojana for the year 2010-11. It was further mentioned that the Deputy Commissioner Dhubri, by the letter dated 9/3/2015, along with the connected papers of documents were received, had placed the requirement of fund for the work of construction of the circle officers Assam type quarter, deep tubewell, boundary wall, etc. There was a request made to the executive engineer PWD B Dhubri to clarify the matter by the Deputy Commissioner Dhubri, but there was no response received from the Deputy Commissioner Dhubri. It was further stated that the administrative approval number B-3/2010/26 dated 16/2/2010 for an amount of rupees 25 lakhs was accorded by the government in the Public Works Department for construction of the circle officers Assam type quarters, deep tubewell, boundary wall, etc. at Bilasipara Revenue Circle under the capital account 4216-CO on housing Assam Vikas Yojana during the year 2010-11. Accordingly, the work was undertaken by the Public Works Department building, and the Revenue and Disaster Management Department was not communicated about it. It was further mentioned that there was no instruction of the proposal in that regard received by the Revenue and Disaster Management Department, and there was no record of any administrative approval as such. Under such circumstances, in the said affidavit in opposition filed by the respondent number 6, it was mentioned that the payment of the amount, any amount of the petitioner by the Revenue and Disaster Management Department does not arise. It further reveals from the records that an additional affidavit was filed by the petitioner on 23/8/2023, wherein, amongst others, the administrative approval given by the PW bracket building department in respect to the work in question have been enclosed as Annexure A. I've heard the learned counsels for the parties. On 11/9/2023, Mr. Ardhor, the learned counsel who was representing the PWD department, had informed this court on the basis of an instruction issued by the chief engineer PWD building that the administrative approval was accorded for the work in question by the PW bracket BNH department. The said instruction was kept on record and marked with the letter X. Under such circumstances, this court finds no reason as to why the petitioner should be kept deprived of the amount of rupees 7,11,000 so and so 700. Inasmuch as from the documents on record, it is clear that the said amount, that the petitioner had duly completed the work in respect to the said amount. This court further finds it relevant to take note of another communication issued by the chief engineer PWD building Assam, issued to the deputy commissioner Dhubri district, dated 9/3/2015, wherein it has been duly mentioned that the physical progress has been achieved to the tune of 31%, and the financial liability on this date was rupees 7,11,700, and the payment could not be made to the contractor on account of the lack of funds. This court has also taken note of that as the petitioner in the instant case was given the contract, was awarded the contract on the basis of awarded the contract as per the in terms with the well-established provisions, was awarded the contract by following the due process. And the petitioner, having completed the 31%, was entitled to the amount of 7,11,700. It was on account of the lack of funds in the year 2015 that the petitioner had not been paid the said amount. Delaying the payment of the petitioner without any certainty affects the rights of the petitioner to carry on his business. And as such, the said action on the part of the respondent authorities in not making payment of the said amount of payment of the amount of rupees 7,11,700 to the petitioner violates the mandate of Articles 14 and 19 of the Constitution. Accordingly, this court therefore disposes of the instant petition, directing the chief engineer, which one? Building. Directing the chief engineer Public Works Department building, building and NH division having its own to disburse the petitioner the amount of rupees 7,11,700 within a period of how much? Within a period of 3 months from the date a certified copy of the instant order is served upon the Chief Engineer, Public Works Department, Building and NH Division. This court further makes it clear that if the said amount is not disbursed to the petitioner within the time frame stipulated herein, the petitioner not only would be entitled to resort to other remedies on the ground of non-compliance to the directions passed by this court, but would also be entitled to interest at the rate of 12% on the said amount from the date of the default. Yes, Mr. Chauhan, you are into this daily market. Shall not be set aside the demand whereby the order dated demand whereby the deputy council settle the inval factor in favor of demand shall not be set aside in clause Kacha factor number demand and inval period operation.
Others matter, they are valuing for market like any market matter. And my lord, it was earlier my lord, reach out to my lord, different matter. And last matter, we paid 60. Paid 60 the last.
Page 1660. Yes.
For one.
Then what are you challenging? 17.4, which is that order? The authority of the so and so is pleased to settle land on annual patta basis to the following applicants. Yes, tell me what is wrong with it.
Giving the minor the possession, my lord, they are recommended for settlement. And my lord, under the rule, my lord, if the hearing dispute regarding the possession matter, then shall not be settled.
What is your right to get the possession?
I am not for my lord getting in the matter because my lord the district council my lord. Earlier we paid my lord the rent to the district council. And my lord, instead of my lord,
No, but Mr. Chauhan, you have to have some right.
my lord, that's right, my lord. But
That is right, mean that is the only right. To make a submission that you have a right. Mr. Chauhan, first and foremost, show me your right to challenge it. How are you in any manner connected? Because you are running a market there. Yes, Mr. Chauhan.
There is a matter of daily market, I only give daily market. Daily market was leased to some other person. Earlier for their 5 years, it was leased to September 6. Now in the 2023-24, the market was leased to some other person, spoiler, at a certain amount, my lord. And the petitioner, they are doing their business in the daily market. The business price is going on, my lord. But out of that, my lord, there is a 4 acres of land. 3 acres of land were allotted to my lord, that is a piece 50, my lord. And they have only challenged only part of that order, my lord, not the whole.
Three kathas means out of,
My lord, only the serial number 2 Dhonsing Dera was allocated land of duct number 1 could be Katha 10 lesser.
uh,
And serial number 3 Augustine Inge, he was allocated 3 Katha land. Itself has only silenced the allotment of land in respect of Dhonsing Dera, not to the another person.
of Dhonsing Dera.
Dera, not
Okay.
to the Amsuman Inge. Land was allotted to him also, my lord. Selectively only they have silenced their order, my lord. Regarding that, we have allocated the land to a person, my lord, who was, application was forwarded to the land advisory board, then it was allotted to him, my lord. And if they have any grievance against allotment of land and cancellation of quota, there is a rule, my lord, they have submitted an appeal before the executive member in charge of the revenue department. And they have not sought to that, and they have submitted the filed the application inscription without availing the alternative remedy. Alternative remedy is also there. They
No,
earlier.
what is the right the
They
petitioner
have,
has?
it is a doesn't have right, my lord. This is the.
They are carrying on the business.
This is the doing their business, and it is the.
In these lands.
My lord, if this is a government land. Out of this government land, my lord, 40 has land, we have stated in our affidavit, only 3 kathas lands were allotted to the person concerned out of the dump number 140. And the market is going on, my lord, and they are doing their business in the, but if they have any grievance against allotment of or influence of another person, they can approach the authority, my lord. as per
So the market has not shifted.
Not shifted, but the market is here, my lord,
And that market is a market of the district council.
district council.
And the district council yearly settles with somebody.
With somebody, my lord. Earlier in
And it has been settled to you.
my lord. At that time, my lord, now no. At that time,
You are the LOT.
I am the allotted. At that time, my lord, in the 2023, 24, we have allotted to some other persons. My lord, that order is also, my lord, that is the.
And that LOT only collects the revenue from him.
Yeah, my lord, that is my lord. And response number 6, it was allotted to the response number 6.
But tell me one thing, if the land now becomes the land of the LOT,
No, allotted, my lord. Out of the 4 weeks, only 3 kathas land.
becomes the land of the LOT, can you run the market there?
But there is actually another land, that is the land, equal area of the land was the 4 acres, my lord. Out of 4 acres land, we have allotted only 2 kathas land. Out of 3 kathas, 3 acres and my lord, 2 kathas lands were there in that particular duct. There are 2 ducts. So in those ducts, lands, those who were not allotted, in the market is going on. In 2023.
So the market is going on in the non-allotted area.
Not allotted area, my lord. And this is the order, it is the, we have allotted to the another person, my lord. This is the order, my lord, we have
So the market is going on.
going on, my lord. This
And the market is going on in the non-allotted.
not allotted area, my lord. From back, my lord, market.
Understood, but in the non-allotted area.
Well, can you see what document is given? It says 62, my lord, this is the copy of the PI, so a record of the my lord authority. Says 62. Here are my lord 5 number of ducts are there. Tag number 137. My lord,
Page,
somebody is.
862.
And it's
So, it is an asset.
duct number 138, it is my lord daily budget.
But it is a remark. But land is a for car, it is a government land. Remark is there, this is going on there.
Yes, my lord, it is a daily budget, 138 and 140 my lord, also daily budget. So my lord, the land of the daily budget, out of daily budget, my lord, I could see. And my lord, can you see what is more, my lord? What the annual patta says, my lord, the annual patta, I think.
page,
Says my lord, 55. Says 55. This is my lord, I am reading, my lord. যেহেতু অসমৰ ভূমি আৰু ৰাজহৰ বিধি ব্যৱস্থা আৰু সময়ে কৰা তাৰ নিয়ম বশৱৰ্তী হৈ ইয়াৰ লগত তহচিলৰ লিখা মাটি আপুনি দখল কৰিছে এই চিন্তা কৰি আছে তলৰ লিখা চৰ্ত মতে আপোনাক 2018-19 ৰাজহ কাৰণে কোটা দিয়া গ'ল। So my lord, the suggestion is the first requirement is to get security.
understood, but who are you?
My lord, I am my lord, we are my lord, of the locality, I have, my lord, My lord, living there, my lord.
Now, okay, that I am satisfied you have no right. Now tell me why cost should not be imposed upon. Tell me that submission.
My lord, because my lord,
Because unnecessarily filing a litigation out here, why cost should not be given
my lord,
to Mr. J. Suti of 10,000, to Mr. R.P. Sharma 25,000, 35,000, and anybody else
my lord, earlier, my lord, we came, my lord,
40,000.
what is rent, my lord?
Okay, cost of 40,000. How many people are there?
My lord, they are my lord, 21, my lord, I have other person.
Okay, 20. So 2,000 each cost.
My lord, it's a good, my lord.
If it is poor, why they have unnecessarily, why they are not going before the district council? They want to file it before the high court? What is this? And you, for filing, you want to, what right do you have?
It was, yeah.
So it is 2,000 each person will deposit the cost to the, to whom? The registrar. Cost
My lord,
40,000.
my lord, independent, my lord. You love me, my lord, allowed to, my lord, because the district council allowed, my lord.
How are you affected? You are not affected anyway. You are running your business.
This may be due to my lord, except my lord.
No, are you running your business or not? Then- So on lack of bona fides, we are dismissing it with cost.
It might not be, but it might not be discount. I am not avoiding my lord.
I'm not asking you, but what are you affected by the allotment?
So immediate,
Are you affected by your allotment?
so my lord, from long time, my lord, because of market. Yes.
Have your place been changed from earlier place to the now place? How are you affected? Cost
Because my lord, immediate paper. there, my
40,000. Got
lord,
40,000.
my lord, it's,
Okay,
my lord,
20 petitioners,
my lord,
20
case
or
of my
21
lord,
petitioners.
my lord,
That is-
my lord,
We'll make it 42,000. 21 petitioners have joined together to file the instant writ petition challenging the allotment
actually, not my lord. Because, we have to put my lord, 5 minutes because that discount, my lord.
challenging the order dated 17/4/2018, whereby annual patta have been issued in favor of the respondent number 6 and 7, or respondent number 7. You want to withdraw? Mr. J. Sutia, the learned counsel appearing on behalf of the petition, the respondent Karbi Anglong Autonomous Council submits that the filing of the instant writ petition is nothing but an abuse of the process of the court. More so when the petitioner has an alternative efficacious remedy to approach the
Executive member insert revenue department under the autonomous council.
Under
Under Rule 26.
Rule 26 of
Assam Land and Revenue Regulation 1886.
Mr. S. Son, the learned counsel appearing on behalf of the petitioner submits that taking into account the same, he would not like to press the instant writ petition. He however submits that the withdrawal of the instant writ petition should not preclude the rights of the petitioner to approach the appropriate authority if the petitioners are still aggrieved with the impugned order and the issuance of the annual patta in favor of the respondent number 7. So, taking into account the above, the instant writ petition therefore stands dismissed on withdrawal. It is made clear that the dismissal of the instant writ petition on withdrawal shall not preclude the petitioner to approach the authorities concerned. And it is however made clear that the withdrawal of the instant writ petition shall not prejudice the rights of the petitioners to approach the authorities concerned.
One thing, madam, in my life, they are running market, madam, outside I looked at them, then they will not be madam.
Then I will touch on merits. Then the cost is 42,000.
That's for the. That's for the. Transport recommended for homeland the other day has rejected the prayer of petitioner, stating that the consenting party. But that I am using the information.
Where did page?
Yes, for the. For recommendation for listing compensation under so the amended 36/2018 in section case number. Also under section 75 additional section the appears that the victim of a corporate consenting party and she was well aware of the consequences and she does not fall within the ambit of victim compensation scheme and that considered for compensation is hereby rejected. How to do that? Victim has also with 8 years of age is hereby accorded compensation of rupees 10,000. Although the landed transport has recommended for the for compensation, but the TLS has suggested the grammar of case 44. The recommendation made by the landed transport. Case 44. Paragraph 32. It appears from care record that PW to the LS victim is listed moment to get back to a site as a result of friends with the accused. So she may be given victim compensation under victim compensation under this technical service authority. And regarding accordingly, the very first level on 26/4/2019. Our court issued framed for our 24/6/2019. So under the 24/6/2019. My question for consideration is whether Secretary District Legal Services Authority has the jurisdiction under section 27 SCRPC to reject a claim for victim compensation on a reference made by the court. Otherwise, rejecting such claim, can the District Legal Service Authority declare the victim over to be a consenting party? To issue or stand by. It's allowed for on 24/6/2019. But the respondent has not submitted any exhibit to the one. And in the case of the consent method, this is the statement of the victim method. And it is clearly stated by the forcefully.
Mr. Hussain, I'm not going to look into all those things.
second part about the scheme, 2012 scheme. When the court recommended for compensation matter, DLSRB has the authority to pay and determine the quantum of compensation and pay the compensation. This is the jurisdiction of the DLSRB.
How are you a victim?
When the incident occurred, the petitioner will be assaulted.
You did not prove that. You said to the police station that you were 18 years.
No, madam.
Yes, that is what has been recorded in the finding of fact by the Sessions Court.
It is stated, madam, not police, madam, before the court.
Yes, you said it to be 18 years.
Yes, madam, it is said.
Kindly see at paragraph number 14.
PW2, and the LSPT is at, PW has stated that he has stated before the doctor that he was 18 years. In the statement, madam,
From your own statement, it has been mentioned that this incident happened twice or thrice. And when you became pregnant, you wanted to marry him and he said that he will marry and thereafter he did not marry and as such, this is your case. And that is why 376 has been said to be not happen.
yes, madam.
Then
There, madam, in the statement, said, madam, more photographers were used in the hospital. Madam.
I am not going to see that evidence.
It is recorded chapter evidence,
Sorry.
paragraph 14, madam. And this is not the issue, madam. There the issue already framed by the Honorable Court, madam. Further, TLS has the authority, all the court recommended for
Page 16,
compensation, madam.
page 16, procedure for grant of compensation and pay of this. Service of the power. Page 16, procedure for grant.
When the court did not fix,
Yes.
then on what basis are you going to claim the compensation?
Yes, court recommended for.
Yes, recommended only.
And,
Recommended only because of the child.
not only for side, madam. Paragraph 34.
I read it. What does it say?
And it evidence from the case record that.
The alleged victim is a distressed woman. She gave birth to a child as a result of physical relation with the so-and-so. She may be given victim compensation under victims under so-and-so. So what is, in which aspect you fall in?
Yes, madam.
In which? Kindly come to page 19. No, Mr. Hussain, kindly come to page 19. In which aspect you fall in?
Yes, 15, madam.
Yeah, 19. What is your category in which you fall? Huh?
Category 2, madam.
Victim of lynching, mob violence.
Or. Paragraph, clause 3, madam.
3, rape. Rape has not been proved. Then you are not a rape victim. You lost the FIR after 6 months. You had sexual intercourse for 2 to 3 times. That is your own thing. You wanted to marry the accused. The accused did not marry after you became pregnant. Then how do you become a rape victim when it has not been proved? I understand if it is proved, it's a different aspect. Where is it?
My lord,
You don't come under that. Neither you come under 3 minor victim of physical abuse. That also you don't come in it.
Page 16, my lord.
Why should I come to page 16, come to page 19? In which category you fall in?
3, my lord.
3, how do you fall in 3?
My lord, that is why my lord come to page 16. The eligibility for compensation.
Yes, what is it?
4, my lord.
Ah,
Or the perpetrator of heinous crime is not traceable or goes unpunished after trial.
Hmm.
Or the victim is identifiable and the victim has to be rehabilitated physically and mentally.
hmm.
Some victim may also apply for grant of compensation under subsection 4 of section 7A of the Act.
Hmm. Then,
And my lord, the accused was acquitted beyond of reasonable doubt.
no beyond reasonable doubt, you could not prove, there's nothing else. He said that he is not going to marry you and therefore now you are asking for compensation. You lost the FIR because of that after 6 months.
Crime was pregnant, subsequently on one or even part.
After becoming pregnant, only you realized when he said that he is not going to marry.
My lord,
Therefore, you have to come within the ambit of these.
Yes.
Then where do you come in?
yes, my lord, I am coming, four, my lord, four, my lord.
For rehabilitation of victim of human trafficking.
No, my lord, that's 16. Eligibility for compensation.
Then,
Then, four, my lord.
now for you are to be happy. Where do you get your compensation at page 19? You are not a rape victim. That is what the court found out. You are not a minor victim. That the court found out. Rehabilitation of victim of human trafficking does not arise. Victim of sexual assault, excluding rape, then it is 50,000 and 2 lakhs, that's all. Sexual assault at best you can bring in. That, all these things do not come in. So you may at best come within the ambit of 5, nothing more than that. At best, 50,000. No, here the DLC gave the victim's son is 8 years old. Is hereby accorded compensation of 10,000 rupees as victim to and the said amount shall be fixed till the victim attains major.
If you share my lord order, the DLF can detect it like this. While there is a recommendation made by the trial court. This is the issue, my lord. The trial court was satisfied.
Trial court has given that, look here, something has to be given because of the son. That's it. Yes.
Not my lord, son, my lord. So she never given this information.
Why?
She never given.
Why? Obviously, it is a minor. How can you give it to the you can't give it to the minor. It has to be given to the mother.
And more appeal has to the parent. No, appeal is pending. Again, this judgment appeal is pending.
You have filed the appeal.
Yes, my lord.
Fantastic. Let this matter come up after the appeal. Tell me the number. Huh? You know the number? Huh? That the matter will be listed after the puja vacations.
22.
Yes,
By the intention of the petitioner was rejected as having group one. And instead of considering him under group two category, he was considered as group three. It is my. Down, project number respondent is just for this. That my then, all in a category that I am not, and I is not my own name or not, Nara is long term business. My is the farm of our.
it is
Farm of our.
one more. Card.
I am coming.
Okay,
But the federal education is within the jurisdiction of Swayan Kenani Bhakti Reserve. Where neither performance nor any long-term can be handled. Federation is located on the state 15 law.
then
I applied law with
has it been given to anybody?
law. Till today, there is the page 17 law my location is for serial number 90. मैं अपना कहेंगे बुलाकर
So there is a stay.
page 17 is the location.
Where is the location?
Serial number 90.
Page?
17.
Yes, where? Serial number?
Serial number 90.
Where is it? Angarakha, Arangapara, Sariali, Gulaghat, T.O. Iman, Tiniali. Bypass via Dhansiri water tank. Open. Then
Number 6. As per third of it, possible that number 6 page 24. These are the selection of it. Land loss.
so you don't have a suitable land in the advertised location. You don't have. Neither you have a long-term lease. No. Now you come, applicants having a firm offer for a suitable piece of land for purchase or which can't happen. You can't purchase. Or long-term lease for a period of minimum 19 years, that can also happen. Now, can you have a long-term lease? So you don't come under group 3, group 2.
They want the registered.
Understood.
I cannot.
No, registered lease is group 1.
Group one.
Group 2 is, can you have a firm offer for a suitable piece of land for purchase? No.
No.
As per you,
No.
you cannot have,
No.
because you can't purchase that land.
No.
Can you have a lease over that land? So you don't come under group 2. So your only thing is group 3.
One device is in this particular land.
Yes.
That land fall under the forest land. Back to that. In that forest location, the person whom for whom was the right to the movement of a given lottery. That was another forest right, forest right, they have been handling that. From that perspective, I am executing a memorandum of understanding for applying it to the oil company. That they have not considered.
Obviously, they can't consider that. Because tomorrow, if that person is thrown out, their investment will go to the drain.
In that condition, they cannot provide their retail outlet to any party.
Have you got anybody?
That is not a setting level, wherever this land is falls under forest.
Yes.
For group one, madam.
Hmm.
For group one, madam.
Group one, not possible.
Yes, ma'am.
He admits.
Yes, ma'am.
Then,
Now the candidate seat is 67.
hmm,
This madam, this ends, I don't see a point there is for two, madam.
Hmm?
It's-
I have perused the documents. Who is he?
the petitioner, madam.
Amit Agarwal. Who is he? Petitioner
He's a-
of the petitioner.
There's a clause, madam.
I have perused the documents, so and so, Iman or Iman who had applied for retail outlet for the location of there. I have perused the Iman. In my opinion, as per the requirement of OMC, real piece of land is so and so. I have gone to the lease agreement for the land of so and so who had applied for retail Iman for Iman. I confirm the lease agreement as a provision to sublease the land to the village.
Our candidate seat is 18, madam.
Hmm?
Is 18, madam.
Or what? Why?
The first condition is that the petitioner has to go to the portion, madam, before applying for any petition, madam.
Has to go to the,
The portion, madam, our guideline, madam.
yes,
See, madam. Is 18, madam.
yes.
For applicant in their own interest, carefully go to the portion and understand that condition of selection before submitting their application. Now, land is defined in the page 24, madam, of the portion, madam. Now, madam, can you see? Page 41, madam. So. Registering as an SMS letter will be sent to prospective applicant, indicating that the details of the voters should be filled up carefully. And in case of the
Mr. Council, don't come from here to there. It is not required. Here is the case, because I have done a lot of matters of this, so I know. These are the three groups. These are to be done on the basis of laws. Now, if you have people in group one, they will be first put into that lot. On the basis of the lot, if somebody gets it's okay. Group two is those persons who have a firm offer in respect of purchase as well as for lease of 19 years, 11 months. Group three, who does not have. Now, the thing is, in there, if there is a case where group one, group two is not there, then group three will come in. And in that thing, they are to, within a particular period of time, acquire a land for being given out. That's it. The entire thing. So now, here is the case that petitioner does not come under group one, although he applied for group one. So if the petitioner does not come for group one, and he doesn't have a firm offer for that, so then the only thing is that the petitioner can go to group three. That's all. What else? He says that this is a land in which there is no person who can have the ownership of the land. Fantastic. If that is so, we will be again brought into the draw of laws. Then what is there to challenge here?
My case is considered
As group three. Obviously, group three. If can no, tell me one thing. As per you, forget about the other things. As per you, can there be group one in this land? No. Can there be group two?
farm offer and I can.
Farm over can't happen. How can you purchase?
Farm offer.
Can there be a farm offer for land which cannot be transferred? No, tell me. Can there be a farm offer for land which cannot be transferred?
Farm offer, they are transferring of the land is not there.
What is there?
On affidavit for
No. Farm offer means you have an offer by which you have an agreement for sale, for purchase, or for lease. Can you be? Now, can you have a farm offer for land of that type? Or have they got anybody who has a farm offer? Yes. Is there anyone who is in the group one?
That is the matter of the process matter. So now, madam, just the remaining candidates, madam, who have a madam,
If there is a group 1, then group 2, group 3 has no business. Patterns, what is there? Where is that impugn letter? Yes. You will be considered with group 3, so what is wrong? Unless the matter has been stayed for all this while. The instant writ petition has been filed by the petitioner, being aggrieved. By the communication dated 11/6/2019, whereby the petitioner's application to be considered in group 1 was rejected, and the petitioner's candidature was placed for selection along with group 3 applicants as per the guidelines. For understanding the dispute, this court finds it relevant to take note of clause 4, Roman 5 of the brochure for selection of dealers for regular and rural retail outlets. A perusal of the said clause shows that the applicants would be classified into 3 groups on the basis of the land offered or land not offered by them in the application form. Group 1 relates to those applicants having suitable piece of land in the advertised location, /area, either by way of ownership, long-term lease for a period of minimum 19 years, 11 months, or as advertised by the, what is OMC? Oil Marketing Company, bracket OMC. Group 2 relates to those applicants having a firm offer for a suitable piece of land for purchase or long-term lease for a period of minimum 19 years, 11 months, or as advertised by the OMC. Let me just finish this. Group 3 are those applicants who have not offered land in the application. It is relevant to take note of that applicants coming within the fold of group 3 would be processed advised to offer land only in case no eligible applicant is found or no applicant gets selected under group 1 and 2. Further to that, it is mentioned that in case the land offered by the applicant under group 1 and group 2 is found not suitable, not meeting the requirement, then these applicants under group 1 and group 2, along with applicants under group 3, would be advised by the OMC to provide suitable land in the advertised location, stretch, within a period of 3 months from the date of issue of the intimation letter to them through SMS /email. It is further mentioned that in case the applicant fails to provide suitable land within the prescribed period, or the land provided is found not meeting the laid down criteria, the application would be rejected. This court further finds it relevant to take note of clause 4J, which stipulates the various situations of ownership for defining own/firm offer as stipulated therein. In terms of group persons coming under group 2, land group 2. There has to be a consent letter in the form of an affidavit / power of attorney from the other owners. That is in Appendix Roman 3, capital A. Further to that, clause 14 stipulates the selection procedure. In terms of, as the instant as from the perusal of the advertisement dated, what is the date? 25/11/2018, and more particularly taking into consideration the location for which the invitation, the notice for appointment of regular / rural retail outlet dealership was issued. It's stipulated at serial number 90. It is seen that the said selection would be made on the basis of draw of lots. Clause 14G stipulates the selection through draw of lots. In terms of the said procedure mentioned therein, list of applicants bracket group 1, group 2, and group 3 bracket close would be prepared on the basis of land offered or land not offered in the application by the applicant. In case of the locations involving selection through draw of lots, if there is only one eligible applicant, no draw of lots is required. The lone eligible applicant would be declared as the selected, and email would be triggered by the website to the single eligible applicant's email. In case of locations involving selection through bidding, it is further mentioned that draw of lots / bid opening would be held first for the eligible applicants in group 1. Draw of lots / bid opening for eligible applicants of group 2 will be held only if there is no applicant in group 1, or applicants in group 1 have been disqualified / not found suitable or have withdrawn. In the backdrop of the above, let this court therefore take note of the facts involved. As above noted, the notice for appointment of regular / rural retail outlet dealership was issued on 25/11/2018. The instant repetition pertains to The location, Erengapara, Sariali, Gulaghat, T.O. Kosarighat, Tiniali, on Gulaghat bypass road via Dhonsiri water tank. It was an open category advertised location. And it was mentioned that the mode of selection would be draw of lots. From the records, it reveals that the petitioner submitted his application, his or her. The petitioner submitted his application. Page 53. On 23/12/2018, in the same application, the petitioner applied on the basis of applied as an applicant falling within Group 1. At clause 13 of the said application, the land details were mentioned of one Bonti Gogoi, Pankaj Gogoi, mentioned that the said land offered belonged to one Bonti Gogoi, Pankaj Gogoi, and Tiken Hazarika. It was further mentioned that the date of registration of the sale deed, gift deed, registered lease deed, the date of mutation was 21/12/2018. The same document, on the basis of which the petitioner claimed to be in Group 1, to fall within Group 1, is a notarized lease deed dated 21/12/2018 between the owners of the said land and the petitioner, between the purported owners, between the alleged owners of the said land with the petitioner. A perusal of the said document reveals that the period of lease shall be at will of the lessee, and the deed of lease may be renewed after expiry of the term of 25 years on the same terms and conditions. This court at this stage finds it relevant to take note of Section 17 of the Registration Act, 17(1) of the Registration Act, which stipulates 17(1) and Section 49 of the Registration Act 1908, which stipulates that which are the 17(1) of the Registration Act 1908, which stipulates that stipulates the documents which are compulsorily registrable. Taking into account clause 3 of the lease deed, dated 21/12/2018, the said document is compulsorily registrable. The effect of non-registration of a document which is compulsorily registrable have been mentioned in section 49 of the Registration Act 1908. Stipulating that a document which is compulsorily registrable, if not registered, shall not affect any immovable property. Under such circumstances, the said lease deed cannot confer any right upon the petitioners over the land in question. More so, the said lease cannot be also said to come within the ambit of a registered lease deed. Taking into account the above, the petitioner therefore cannot come within the ambit of Group 1. It is further, this court at this stage finds it relevant to reiterate that as per clause 245, if the land offered by the applicant under Group 1 is found not suitable, not meeting the requirements, then the applicant under Group 1 has to be considered along with Group 3. As the petitioner never applied as a candidate coming within the fold of Group 2, the question of the petitioner being placed at Group 2 does not arise. Under such circumstances, this court finds no infirmity in the order dated in the communication dated 11/6/2019, by which the petitioner application for considering as a Group 1 was rejected, and the petitioner being placed for selection along with Group 3 applicants as per the guidelines. In that view of the matter, this court does not find any merit in the writ petition, for which the writ petition stands dismissed. The interim order passed earlier stands vacated.
By mistake in the form, but I have public all document in the Group 2.
There, can't help it. No, not only that, if that land cannot be given, you can make out the case later on that if somebody, as you say, there cannot be any land.
20 to 25.
Yes, madam. What are these matters? Without paying you due compensation. I didn't get you. You are paying for? In which one? Name, number? 465. Yes, tell me. What is your case? Huh? Interim order is there. What is this interim order business? Yes, Mr. Barbudari. What is this? Enabling them to avail all the protections available under the land acquisition if required of the scheduled land still survives to the requiring for getting up the integrated from taking over the possession of the scheduled land until and unless proper acquisition notice to the petitioner enabling them to avail of the remedy. Now, what is left? You have acquired? You have acquired? You have acquired? Then what have you done? You have received the compensation.
But this respondent number 6, and protecting in condition with the individual stuff, what is name mutated over the content of that.
Huh? What did you do?
That is this respondent number 6, and the condition with the individual stuff. What is name mutated over the content of something that. So from the record of right, they were upstairs. And
So you are entitled, not the respondent number 6. Now, why have you got the respondent number 6 name struck off? Okay, respondent number 6 has died. Now, has the respondent number 6 received the compensation? Have you paid the compensation? You have not, because of the orders passed by this court. Now, in view of the notice, having regard, it is provided status quo as regards the disputed land. Status quo as regards disputed means you are not being able to take it. Submitted at the bar, respondent number 6 has expired in the meanwhile in a police encounter. Oh, you killed him. Okay. In view of the above, the name be deleted. Shall file so and so. Till then, the interim order dated so and so shall remain in force. What is the interim order? Status quo as regards the possession. So you have not been able to take it. You don't want it. We'll have it. We'll issue rules. No, people will be thinking that this court is trying to vacate all these things. Let these people also enjoy, isn't it?
See, digital is all our part. Although land port authority is released the whole amount of it, but we are not able to locate.
Who are you?
I am for land port authority.
Land?
Land port authority.
Landfall.
Land port authority.
Okay, land port authority. You have not taken the land.
We have released all the amount we have released, but due to that reasons, we are not able to.
What reasons?
Status quo and other things.
No, status quo will be taken care of, but you people, there is no urgency on the part of the government.
We are not able to look at the project.
Ask the money from her. Ask the money from her, the deputy commissioner. What is the deputy commissioner doing? This is the acquisition under what provision? 1894, before 2014. The matter is still pending. Don't blame this court because because why you are saying because this has happened in 2019. Then what were you doing all this while? You initiated the proceeding in 2004 prior to 2014. Otherwise, you wouldn't have done under 1894. So therefore, when you have initiated, the Land Acquisition Act stipulates 1 year for notice for section 6 and then 1 year for at best 2 years for the award. So it makes it 4 years. What have you done? Unnecessarily, Mr. K. Gogoi has been troubled. Yes. And you don't have instructions.
That is the difficult data. Academic finding area in biology. Total repetition. That only springs out that who is having for which part of the head. What is the data? But yes, but
Mr. Borpuzari, we are not bothered with all this. Simple question is, have you passed an award? No, you don't know. And if you have not passed an award, the matter has gone for a 6. You can't. Number 2, if it is a dispute between them and respondent number 6, who is going to get, they can very well approach the authorities for making a reference. But you are not making it clear. Does it take so many years? And if it is their land, who is going to pay compensation? Tell me, the interest. Are you in possession, madam? You are in possession. Be happy. Let this interim continue for ages. The next 15 years. So what do you propose? Isn't it the most simple matter out here? The earlier matter must have been more tough. No, the earlier matter must have been something about group 1, group 2, group 3. This is a simple thing. And does it take from 2019 onwards? Forget about the affidavit. I'm not on the affidavit. You are to only find out have you passed the award? That's all. And what has happened to the acquisition proceeding? Nothing more than that. And you bring it to me. I'll take care of whatever is required. I don't require your deputy commissioner's affidavit. These deputy commissioners have a lot of problems tackling the administration and all. So let them give it to us. We will take a lead.
That aspect of the matter is absolutely silent, madam.
There are 3 LA cases.
What is the number of
You produce the records of the 3 LA cases. We'll see. When? Friday. Where is it? Karimganj, not far off. There is an order on 16/2/2022. On the said date, the Deputy Commissioner cum Collector District Commissioner shall place the following records in original regarding acquisition of land at Uttarkondi, Japrakata, Oyewan, so-and-so in the district of so-and-so. And I don't understand how these are being done under the LA case of 2016-17 if it is under the 1894 Act. Are you sure? 1894. Okay. Pleading, they also don't know. This government keeps everybody in dark. This court have directed, then also the Deputy Commissioner does not care. Where is the notification and the notification? Madam, where is the notification? Necessarily all these things. Who is doing what and all? This. Now, if it in the record of rights, the name of the respondent number 6 is there. This court can't pass an order against the dead person. So you have to constrict yourself to doing that. How do you take care of these proceedings within the ambit of 1 to 5? And there is Mr. Barpujari to cause more trouble to you. Yeah. Whom-
Item number 24, the next statement, but I find from the previous part of that. This already you can see that it's final before I go down to the Munshi.
That is okay, that is okay, but it is a case of apportionment. Who gets it or not, they have to make a reference. But whether the award has been passed or not, we don't know anything. And the deputy commissioner is relating all these things, whose name should have been there or not. To stop. Laho. Let the matter be listed again on when, madam? Karimganj, when? Nearby to? Karimganj is nearby to? Bangladesh.
That is the one. Contact of Mr. Important, but then if you 12th of October, first day. 12th of October.
Why? Why on a Thursday for such a simple matter? She doesn't like the number. We'll have it on 9th. Why do you need it? Why do you need so much when there is already an order passed by this court to produce the records and not been done? In fact, it should have been done by today. If it was before 10:30. Right? List the matter on 9/10/2022-23. On which date the deputy commissioner cum collector district Karimganj shall place the records in original regarding acquisition of land at Sutorkandi, Japorakata, Kite, Balingarpar for Land Port Authority of India in the district of Karimganj. The cases are number 1, LA case number 21/2015-16, number 2, LA case number 22/2015-16, and number 3, LA case number 4/2016-17. Good stuff. A copy of the instant order be served by the registry to Mrs. S. Borua for due compliance. Yes, what is this? What are you asking for?
So, my lord, as the Senate Government Council, so.
To pay the death benefit against policy of rural post life insurance to the petitioner since he is nominated person amounting to 1 lakh plus 8% amount for delay beyond 8% of 60 days. What is this policy? Madam, what is this policy business?
That, other of the, but it is a good year because the land by land. There was Nipco and Finland has been given to the British father of the British land. Then second policy was issued on 2013. Within the 6 months of that policy, matter the father was expired, father expired, the particular father expired. So there are some rules when someone expires within the 3 years of the policy, rather. So when they while going for the verification of the document, rather, they counted, they have produced that document for their age certificate, but that is page 9 of my application.
Then
That was, they found that there is a good in that, in the, I mean, they have given the school certificate, but there was no school in that name, minor. Okay, that- That is minor.
but you are claiming that he has committed fraud. And who issues this policy? You are paying for the post office. And there is no other place where a person can decide all these things. How can this court keep on deciding all these things? Whether he is the right, you are alleging fraud. How can this court decide?
Therefore, the court, earlier occasion may not have then filed the confidential inquiry report, madam, on the basis of which may not.
How can they file the confidential inquiry report when you say that it is confidential? It doesn't become confidential if you file the confidential report. Chalo, madam, you do one thing. You bring on record, don't bring on record, you produce the confidential here. You have it? You produce you bring it in seal cover, you look into it, and if necessary, are you claiming privilege on that document? Why are you saying so? Do you have instructions to that effect? Then why are you saying just because it is confidential?
That person, 5% next payment on bill government.
Let the matter be listed again on 4th of December 2023, on which date Ms. A. Gayan shall place this before this court, the confidential inquiry report dated
Notice has given.
in respect to the petitioner. Yes, what are you?
And it was referred to the arbitration. The deputy commissioner also filed application for arbitration, and accordingly it was referred to the arbitrator. Arbitrator took up the matter, and finally final award was passed on to the with 97.
Yes, who is appealing for? Huh? Construction of what?
37A.
52 and 52A? You are not with 52. Huh? You are not, NHAI is not connected with 52.
it was constructed.
52A, it's okay, I understand, but 52? NHA 37A is the road from Koliabor to Tezpur. That's the road 37A. Then 52 is the road from there, from that place, what do you call, Balipara. Balipara onwards, that's 52. Right, yes, you are the NHA and you don't know. And 52A is which one? And 52A, I think, is the road from this place, that Holongi. From starting from Gopur, Holongi, and ends out there at Bandadua. Yes, that's the one. That's 52A. The entire stretch from starting from Gopur on the left, and that Holongi road towards, then it goes towards Naharlagun, then back to Bandadua. That's 52A. Affidavit in opposition is being filed by National Highway Authority of India. Who has passed the award? Under 3G? By the Deputy Commissioner. Arbitrator will come under 3G5 later on. No, that is, he's the arbitrator. I'm saying who has passed the award, initial award, 3G1. By Collector Punitpur. Then this is a very serious implication, this matter. What they are asking is a huge amount. Not only on the question of compensation as per Schedule 1, they are also asking for Schedule 2 and 3 for rehabilitation, which has the far-reaching consequences. And strangely enough, the state government, the government have not challenged it.
Again, the word passed by the arbitrator. There is a mention of NHA. It is not NHAI.
NHIDCL.
They participated. They have to be participated.
The learned counsel appearing on behalf of the petitioner submits that taking into account that NHIDCL have not been made a party to the instant petition, he would like to file an appropriate application bringing on by arraying the NHIDCL as a party to the instant proceedings. So 6 weeks time is granted for that. Government, you file your affidavit. 28. Yes.
Next, madam, construction in a nearby area of the army station matter. Page student include other matter that it is a page 37 matter. Next, 6 matter.
Page. It's
Page 37 matter. Next,
yes.
with reference to the public secretary, I am informing that as per your letter, and on a system to show legal guidelines to take decisions, comment of India, municipal and along with your letter, the understanding has been written to the admin among them. That the taking clarification as to which guidelines should be followed for the sake of no certificate for taking public. In response to our letter, the army apparently by letter that is 17 January 2020 has clarified that the guidelines given at Ministry of Defense, letter number 2020
Isn't that the case where 50, 100, 100 meters, then it became 60? So they can't construct within 60 meters of the military station. Have you challenged the circular?
Yeah.
Where? You have challenged the orders only.
We have challenged, we filed this petition on the basis of that, their earlier guideline was minor amended, new guideline was issued by them. Because it is a big 18 matter, an exact matter.
Yes.
Case 18 and exact matter.
Now, they say this 2016 thing which they have stated has not been given effect till late.
So, their affidavit, they have taken different action of the Indian affidavit by law.
Hmm.
In their affidavit, they have said that the new guideline of 2016, which is in the way of minor process for review.
That is what annexure A, page 45, running page 44, they say. That the 100 meters will still apply
But there.
to reduce the restraint for construction of from 100 to 10 meters. Based upon the taken as service at MO is currently the process of reviewing is 2016. In the interim, so-and-so has promulgated the guidelines and not the MOD guidelines. Then
Their affidavit was the final because of 2021. However, whether they have reviewed the matter or not, ultimately what is done, upon this in Tamil Nadu, that is not articulated. Yes, the thing that-
this is of 2019. What has happened thereafter? Ms. A. Guy and the Learned Council appearing on behalf of the respondent authorities shall obtain instruction as to what steps have been taken pursuant to the advisory. There's construction activities in the vicinity of MIL establishments dated February 2019. This is the matter on 6th of December 2023.
29.
Yes, page, para, page 70. Yes,
Thereafter, an award was made by the Secretary of Form 10.2018 regarding an amount of not as compensation with the petitioner quantifying the repair total for sum of compensation under
then
the paragraph 9. So, when the matter is part of law, the transfer has placed copy of notification that is on to 2019. However, it is of passed on 2000 has been amended.
now how much you have got?
Plus for better.
How much you are to get?
Remain, yes, then, but, 76. 13 and 14. In the light of the above, the portion of the matter needs to be limited back to the DLSS to have to relook at the compensation paid to the petitioner, taking into account the notification of the government of Assam later on to 2019 and the compensation scheme for Sovel, System Services 2018 of NAFTA. As well as the implementer started at this 78.
Then
Implementer that's 78. 27/6/2019.
so they have rejected on clause 7.
The operative part case 81. Paragraph 17, madam. Considering this, I am of the view that already asking for the audit to this as compensation, and I do not clearly.
You are entitled to how much?
That was 2019 notification was 3 to 5 lakhs, madam.
Huh?
3 to 5 lakhs.
3 to 5 lakhs.
And as for now, I think madam 4 to 7.
So where do you get it? You have not filed your affidavit. File your affidavit. The learned counsel, Mr. N. Goswami, appearing on behalf of the learned government advocate. The learned counsel, Mr. N. Goswami, the learned government advocate, seeks for an accommodation of 3 weeks for filing the affidavit. List the matter on 13th of December 2023. In the meantime, the affidavit be filed by 4th of December 2023. Yes.
This land is in legal possession of Alpha members. From 1989, and it is an administrative position. The lordship sees. There's DC also tried to remove and shift the Alpha members from that plot of land. But
What do you want?
I want my lord that them be shifted to another place, and I may be given a position.
Who is it? Who has given the possession to them?
Those official efforts, they don't reveal anything.
Then
Since there's a Alpha members, madam. They not, and not only one person has been there, madam.
you are asking the Salfa members to be removed without making them parties?
Illegal possession, since father-
Illegal possession, legal possession, that's a different thing. First of all, they are not parties to the instant petition. How can this court pass an order?
No records don't reveal, but there is a state element because normally Alpha members when they shift, when they surrender, madam, the state which gives them a allotted area of camp, madam.
Are you saying this?
I'm saying.
Where? From RTA 2015?
Five ends in.
Huh?
There are 5 ends. Even since madam, the DC has accepted at page 31, madam, DC Walpara has issued an order asking them to shift.
They have been observed that the existing camp for providing accommodation to Salfa Military at Walpara is located at a Patta land so and so under the remand owned by Joydian Pura. It has also been that the owner of the said land has served notice to vacate the land from the occupation of Salfa camp. It was conducted by the PC in Man. Considering the above, is hereby decided that the present Salfa will be shifted to the vacant government quarter at so and so. This is the communication of 2009. How are you connected with this person, Joy Chand Lal?
The attorney holder of that land, madam,
You are the attorney holder. Why?
he has passed away, madam.
Then show me the attorney.
His legal heirs are appointed me attorney.
Where?
Lordship at page 18, annex 8.
Who has appointed you?
His legal heirs, madam, at page 19. It starts at 18, concludes at 21. 21 minor is in city commissions. The departments and doctors, Kamala Devi, Vimal, and Manoj. And each has filed an affidavit. DC has yet to file.
Where is your power to seek eviction? Where is your power to seek eviction?
I am not seeking eviction.
You are seeking eviction by way of the instant petition. Where is your power?
Under this page.
Huh?
In page 20,
Yes,
under this page.
Huh?
Clause 8.
clause?
8.
Yes.
So, same concept, same cost of land living.
Where?
8, madam, it-
Where is the power to evict?
expressly the given, madam. I
Huh?
have the power to take possession of my land.
Where is it? No. Where is the to take possession of the land from the authorities? Where is the power? No power.
And thereupon, my DC has to find a spot.
Forget about the DC. Why should we disturb the DC? This happened in 2009. Why you are approaching this court in 2021, 2020?
Madam, because of some communication.
What is this communication? One, after that person has died, he has all along, he did not say anything, and now you, after he died in 2000 so and so, you have approached this court by filing a writ.
Madam, his son says his issues have, should manage this power of attorney, authorizing me, madam.
This court is not going to do anything. You want to throw somebody out, file civil suits.
Pending your honor, madam, this alpha member had fraudulently, madam, transferred the name in the name that allotment. And they have time to, madam, now pursue.
So
Agreement for sale, madam.
Then-
Sale permission,
then,
madam.
the civil suit is your main remedy. Why are you initiating these proceedings?
Since, madam, it is admitted because by the state action, madam, it has come.
Whatever may be, you want to, can there be no suit against the state?
Page 31, madam, you can see. The state element is there.
I've seen that.
Allotment, accommodation.
I've seen that order of the district magistrate.
State provided them accommodation there. I will.
No, the moment considering it is hereby decided that the present sulfur can be removed from so and so to government quarter, meaning thereby the state have already taken action, then they have not been able to throw out.
Page 35, madam. This is the communication received from DC, but the sulfur members have stayed.
They are reluctant to stay.
Yes.
Then why should this court exercise this power, asking them to throw somebody else who is not a party to the proceeding?
They had, because my land was free.
Sorry.
Because of state action, my land is.
If anything else they do it, they are trying their best to throw them out. They have not done it.
Till now, nothing has come. That's a DC final affidavit.
Why should this DC file an affidavit? The DC has made it clear. First of all, you don't have the power.
Person to get, madam, 13 fact that 2009 communication, madam. Madam, see, I'm disputing that, madam, there was a page 38, madam, that there is a claim from compensation has been claimed on behalf of which we directly refused, that we have not filed any kind of complaint. Page 36, madam.
Who is this person? Rusbul to Radha?
He is the leader of those, madam.
Sir. So there is a suit pending.
Yes. And madam, but only one person, madam,
Enough,
14% they were occupied.
enough. I have had too much. This matter has to remain any further.
Madam, perhaps one affidavit for DC, madam.
Why?
I will be present.
You want these proof out here? You want these proofs out here, evidence, so that you can place it in the trial court.
That admitted that this is a state action which has given me trouble.
So what? First of all, what is your power? You don't have the power for that. You have not been granted any power.
I have this final.
No. Power of attorney doesn't mean the power of attorney to do everything. First of all, this happened in 2009. Why you filed a suit in 2020?
Only, and this came to knowledge very later, madam, because it was allotted way back in 1999.
Sorry.
Perhaps I'll seek some accommodation because NJ Khatania was there. It will be his absence and I had to place the matter with this second copy.
At the request of the learned counsel, the petitioner matter stands adjourned to be listed after 6 months.
31.
Yes, Mr. Mahmood.
The present petitioners, father late Virendra Chandra Ghosh, was the rank under the deed and revenue system. And revenue system was established in 1954, but before that, my father was the tenant. Now we have annexed certain documents of revenue time, that is kind of 13 and 15. The student possible change something wrong on this. The system busy as the state has started. So in the name of Virendra Chandra Ghosh. And Bhanupriyar is has called. Then my lord, there is also revenue paying receipt that may be received as 15 and vernacular medicine as 16. Even then, my lord, in the year 1989,
Now what do they want?
69, the Bangladesh municipal would try to return from the plan, so we filed a title search that made it interest 15. And in the title search, 50 was passed in my Baba, that made it interest 19.
Then
20% division test 20. So sometime, for some years, the municipal authority was silent. But now again, they have started to disturb us, so we have filed this petition in the year 2020, stating that they have no power. If anything is to be done, that may be done by the state government. And that too is proceeding. Now, our submission is this, it's not of land.
Mr. Mahmood, why have you not included the judgment? Why have you included the decree? First, secondly, you have constructed it without permission. Have you mentioned that you have the permit? Do you have a permission to construct?
It's not permanent construction, and they have, it's like, that is used for commercial or some.
Huh?
It's not permanent construction, and they have.
Are you saying that these are not RCC? One RCC building is not a permanent construction? That doesn't belong to you. Then how is it permissible? You are saying RCC building is not permanent?
No, permanent.
Taking into account that the judgment has not been included, judgment and decree on the basis of which the petitioner asserts its right has not been included. This is the matter to be list the matter after the Puja vacations. Oh, that one. Yes, circle officer's report.
In fact, today he hasn't served any extra copy, but still then I have taken the couple of certificates from him.
Who has not given?
I personally xerox and send them from.
When?
Also, and the extra copy.
No, it doesn't have it.
No. You have not given. Why should they not give? Then copy of the way for due compliance. Then why haven't you given them? Taking into account that the petitioner have not served the extra copies as directed by this court on 30/8/2023, matter to be listed after the summer Puja vacations.
I'll find the notice. I'll have copy and find the notice.
Petitioner is directed to take steps as directed earlier immediately. Forthwith. Yes, affidavit file. What? No affidavit file. Why? On the last occasion, so Mr. A. Bachchanji took time for filing affidavit. to make payment of the executioner for the death of her husband in terms with the notification dated 15th of November 2014. This is how did the person die?
He died due to electrocution.
Oh, electrocution, whether it will fall within the ambit of it or not. Because your case is that he falls within, outside, or within the epidicial area. And as such, he is not entitled to. But we are not filing an affidavit for that. That?
Therefore, my lord has made a point query, my lord.
Ah,
So what would be the definition of the public place?
hmm.
There, my lord, I am relying on that.
What does it say?
On a document, I can come to the third page, my lord, I page number 69, my lord, there.
Hmm.
So that not complete. I have done 15 in red, but my lord.
A confusion arose as to the definition of public place referred to in the notification. Public place will mean any street, alley, park, public building, and any place of business or assembly open to the any other place which public view.
Find what public places expected here and below. Here, my lord, will-
Where is the electrical accident report? Electrical accident report. Enquiry officer. What did he say? Cause of death, description from the document furnished by the concerned official and gathered by so and so. As per the snap due to storm and immediately the damaged portion of the line disconnected by the lineman. The human and source person English got electrocuted and died when he proceeded to help repair mistake. Facts, it appears the victim who was not authorized to perform electrical repairs tried to restore the electricity connection. On request of some local residents of the village, the victim tried to restore the connection from one. Electrical, yeah. How do you get it? You have done out there to the LT. Is anybody normally, is he entitled to fiddle around with the LT lines?
So otherwise, I was directed, actually, filed by the respondent, I dispute that here. Otherwise.
No, we are going as per the inquiry report of the inquiry in electrical inspector. When in paragraph number 10, he says, page 49. That from the facts leading to the accident, it appears that the victim who was not authorized to perform electrical repair jobs tried to restore the electricity connection. On the request of some local residents of the village, the victim tried to restore the connection from another LT feeder coming from other substation and thereby got electrocuted as the disconnected demand was somehow charged. So it happened at that particular place where the LT line was there. So how can you get the benefit under 1511?
Otherwise, I was verbally directed to repair the damaged line.
Who?
The responding authorities directed me to repair the damaged line. So I have mentioned it in my paragraph.
Who has directed you?
The office clearer of the electricity department.
Understood. So it may be at best the APDCL must have directed you. Let us assume APDCL have asked you to do it. And when you went out there, it happened. Now, can you say going inside the substation or wherever it is, which comes within the ambit of APDCL, to be a public place? That is the question.
My understanding is that the was electric post was within the premise of public place. That's the reason.
How?
And because that was lying on the public road, you know.
Understood. But is that property belongs to the government or anybody, or is it a person who is can frequent to or touch that particular line.
Frequented by the Lok Sabha. Otherwise, I was not a public part, your Lok Sabha. I was under the authority of the departmental here, your Lok Sabha. I went here.
So obviously you may be entitled for whatever may be from the compensation from APDCL, that's a different thing, we are not on that. But how can you get under 1511 to be a public place?
That is the understanding, my understanding of worship, that because that elected post falls within the ambit of public road, your worship. And which authority I went there to repair the damaged line, your worship. That's the reason why that comes within the public of scope of public place, your worship. And that was an accidental that, so the accident caused within the public place, your worship. And this is the reason why my case falls within the notification dated 2015, your worship.
Difficult.
Because no one the term public place is explained in the notification. No, it is there, but this is an I have just there is a notification.
Public place will mean any street, LA, park, public building, any place of business or assembly open to or frequented by the public or any other place which is open to the public view or to which public has access. Thus, do you have an access at the public?
That is not accessible to the public at large.
And
That is not.
then how do you bring in using that? Anyways, you file your affidavit. Why should I dismiss his petition without your affidavit? Indeed,
So if you also search some law case.
fantastic. The respondents on 30/8/2023 gave an undertaking that the affidavit would be filed within 10 days in terms with the order dated 14/8/2023. This court, taking into account the above, directed the respondents granted additionally another 11 days beyond the 10 days requested and fixed the matter on 21st and fixed the matter today for filing their affidavit. But the respondents and fixed the matter on today and directed the affidavit to be filed by 21st of September 2023. However, the affidavit which was to be filed by the Revenue and Disaster Management Department have not yet been filed. This court therefore directs the Revenue Department of the Government of Assam to file the affidavit gives an additional opportunity for filing the affidavit by 10th of October 2023. Lists the matter on 13th of October 2023. This court further imposes a cost of rupees 7,500 upon the Revenue Department for not filing the affidavit within the time as directed by this court. Yes, what is it? Setback. Recently, 7/9/22 is recently. Huh? Oh. That's right. You have a stay? We vacate the stay, then we will see how urgent you have. What do you say? We vacate the stay, then we will see whether there is any urgency or not in the matter.
Yes, I've been trying to read the client, some reason it must be able to come to find the.
Anyways, I have not extended the interim order earlier. The learned counsel, Mr. J. Das, appearing on behalf of the petitioner, seeks for an accommodation of 4 weeks for filing their reply to the affidavit in opposition filed by the Nagaon Municipal Board on 8/9/2023. List the matter on 11th of December 2023. No, earlier also I did not.
Earlier, actually, the application was not in the record yet also.
Earlier also I did not extend. Can a thing which is not there in existence be extended? You satisfy this court that there is a requirement for an interim order, I will pass. Can you extend something which is not there? Tell me.
But
Can you extend something which is not there? No.
it is also not discontinued a lot. It implies that
Next. Sorry. Yes.
Here the stipulation filed by the challenging the order of cancellation of the next of kin certificate. Issued in favor of the petition. Now, let me take to the order, the case taken here.
Page.
28.
Yes.
Here, there is the report submitted by the Central Officer of the Student. Regarding calculation of NOK issued to the amount of reduction. Whereas on the original of the aforesaid report, it appears that the NOK certificate ratio is Kukulnath, Kungalnath, and Forestnath, and Shivanath. These are the petitioners are the inheritor of Vijayaswari Prasad, and on the other hand, as per the voter list, Subro is now is the father of the aforesaid person.
Yes, what instructions?
in the record will call for, we have the record. And there was a complaint being lodged by, on Mr. Sadhan Singh, saying that some fabrication document has been used, to get the NOK in connivance with the law model. And the report of, the additional deputy commissioner and the law control.
Your name is what? Kutulnath. You are the sister-in-law. Sister-in-law means?
This is my Vijayaswari Prasad was the cousin of the husband of the petitioner.
Cousin of the husband of the petitioner.
Number one. He expired.
Cousin means how cousin?
Brothers. Their fathers were brothers.
Fathers
Father of petitioner, husband of the petitioner number one, and the Vijayaswari Prasad.
were brothers.
Cousin brothers.
And you become a next of kin.
If we apply, because my Vijayaswari Prasad had no legal hair.
Had no legal hair. Vindeswari Prasad had no legal hair. Okay, now let us see in whose favor it has been granted.
24,
In whose favor it has been granted.
page 24.
Now that I have seen. This is yours.
In favor
This
of-
is yours. And where, in whose favor it has been granted.
The king certificate has been cancelled.
So it has been not given to anybody else.
Not very clear.
Okay. How do you have a right over that to get a next of kin? The Vindeswari Prasad had nobody.
Had no. We have connected legacy data one.
Hmm?
Legacy data one. Page 26.
Bormon Kurmi. Vindeswari Kurmi. Vindeswari Prasad. Vindeswari Prasad and Kurmi is same.
They belong to the Kurmi caste. Here, minor will find student and Prasad Kurmi.
95. Legacy data. Kindao. What is this? Ramhit. Okay. Vindeswari Kurmi
Father
Supal. Her father's name is Sukal, Suklal. And
Serial number 3, madam.
and how are you involved? Your husband is, what is the name of your husband? Huh?
Serial number 3.
Surya Khan is Boman Kurmi. Then why the name of Janki Kurmi is not there? Why the name of other Boman Kurmi is not there? Why Kusina Kurmi is not there? Tell me. Because you have applied, others have not. There has to be a justification, no? Because the moment you get next of kin, there are a lot of other benefits which comes in. So under such circumstances, why your name has been brought in? Putul Kurmi, Putul Lat, sister-in-law. Putul Lat is the wife of Suryana. And why Kusina Kurmi's name is not there? Boman Kurmi is not there, Surmati Kurmi is not there. Even his own brother, Janaki Kurmi is not there. All. How do you say? Here the next of kin certificate of Sri Putul Kurmi. Putul Nath, so and so are the inheritors, and on the other hand, as per the voters list, Zoid Doi Rot is the father of the aforesaid persons. Zoid Doi Rot. And there is a discrepancy in the this matter of the very well.
Page 29, transfer certificate of Suryanath.
Suryanath is who? Suryanath Kurmi. Ram Bachchan, son of Ram Bachchan Nath. Suryanath again. Here it is written as Bapan. Baman. Then Suryanath Kurmi, father's name is Ram Bachchan. Suryanath.
You know, have also annexed the electoral letter under case 32 because the name of the
Suryanath Chokidar. Suryanath Chokidar. Suryanath Ram Bachchan Nath. Putul Nath, wife of Suryanath.
case 36, madam. There, madam, the surname has been wrongly been checked, madam.
Suryanath Roth.
Wrong. And with regard to that, madam,
Name of the relative so and so. Where is Vindeswari? There is something wrong. Very seriously wrong. What is wrong with this?
we are challenging the order, madam, on the ground that the petitioner will not implement any
Notice.
notice.
What notice is required?
So, better, madam, that Suryanath here, madam.
Tell me, when your name has been entered, did you give any notice to anybody else? Why these, have you mentioned why the other person's names are not there in your petition? Have you mentioned why the other person's names are not there? Putul Nath. Next of the king. Surya Nath, Putul Nath, Purnima Nath, Josuda Nath. Purnima Nath, daughter from Kundan Nath, Forest Nath, and Shambhu Nath. What about Dharmanath? Why he is not there in the next of the king? What is the reason why? Why there is no name of Purnima Nath, Josuda Nath? Why? What is wrong? Rightly done.
So, madam, can you see that of four, madam, they will take it to Suryanath, leading his wife and to the next.
File your civil suit, file your civil suit. This is not the way. They have rightly done so. You have not been able to show how Bindeswari Kurmi has any connection with you.
I will give you one opportunity for.
Fantastic. Learned counsel appearing on behalf of the petitioner seeks for an accommodation to be listed in the month of January 2024. What interim order? Interim order for what?
On the basis of the next of case certificate, the land was divided in the name of the business. Then one was that there is no order, forcible order will be taken for the petitioner.
Mutation in whose favor?
The favor of the
Your name is in your name. You have got the name in your name on the basis of a next of kin. My goodness, no, sorry, I'm not going to do it. This type of orders can't be there. How do you get this sort type of order? You have got a mutation of a land in your name on the basis of the next of kin. This is a pity. Should I mention that this court is not convinced with the matter for which the interim order is vacated? If the matter come in the month of. I'm not extending this type of orders. This court didn't hear it. Tell everybody that there is an extension, they may hear, but I'm not going to extend it.
55.
January 2024,
Can it be
December. Let it be in the month of December. He ordered me. Yes. Miss M. Devi, the learned counsel appearing on behalf of the petitioner submits that the petition has become infructuous. Taking into account the above, the incident with petition therefore stands closed.
Okay. 56.
None appears on behalf of the petitioner on call. On 18/9/2023, when the matter was listed, the petitioner was also not represented, and it was made clear that if the petitioner is not represented, the instant petition would be dismissed for non-prosecution. Taking into account that the petitioner is not represented today, the matter stands and the petition stands dismissed for non-prosecution.
57.
Yes. Yes, Karimganj, DC. As regards the present status of the title execution case pending. Oh, yes, what did you get?
Today is the holiday.
What?
Yes, in the district court of holiday.
Did I ask you to find it today or yesterday also you could have found, or on that day also could have, but this was on 20.
After the court of Saturday, Sunday, and this Monday.
20 was Saturday, Sunday.
Some order need to apply that.
Why do you need to apply? You can very well ask your person and go and check it out. It is available in the e-court. Do I need to show you how it is? How do you apply it?
That's what I read about. Some part they have available the position, but the Sunai Sera is and some land is not available the position.
How the handing over possession has happened on the basis of the execution proceedings?
Yes.
Huh?
On the list of titles.
On the basis of the execution proceedings?
Yes.
Yes, madam, what is your instruction? Karimganj does not want to reply. Then, okay. Ms. Esbulu appearing on behalf of the petitioner. Okay, appearing on behalf of the deputy commissioner, seeks for an accommodation to obtain the instructions in terms with the order dated 29/2023. So, Mr. Your name, A.U. Ahmed, the Learned Counsel appearing on behalf of the petitioner, submits that pursuant to the certain orders passed in the title execution proceedings, some portion of the land have been handed over to the petitioner. However, he has no updated instructions in the regard. So, taking into account the above, list the matter again on 10th of November 2023. The counsels appearing on behalf of the petitioner and the respondents shall ensure that the instructions so sought for by the order dated 29/2023 is placed before this court on the next stage.
58.
Yes. You filed it.
But I still get tired to contact about not responding. What some active of the plan, but
Huh?
not getting a response.
Yes, did they submit any representation?
And in the meantime, madam, another same situation, madam, same fact, same village, madam. This court has passed an order.
Where?
In the recap, by 213. Here also, madam, whole Solamona, same for this village. madam.
What happened?
It is dismissed.
Evicted?
I mean, this petition will be evicted, paragraph 8 of the petition, madam.
They are entitled to what? Nothing?
But they have to see this, approach the government.
For what?
Journalist, madam.
That's a different thing. They can do that. But what otherwise remains. That day I passed an order. Have you looked into it? That matter?
Yes, sir. Yes, sir, put it up.
I've dealt with it, how the
3
what-
months time everything.
90 days.
There is also, madam,
No, what he is asking for, no, he has been already evicted. So now the question is for allotment. You have to seek a allotment application. You don't have any right. No, there is no rehabilitation business. It is reserved forest. Mr. Gogoi, is it reserved forest?
It's a reserve forest village, the allotment. And I am paying the land rent. Pays 22 lakhs in my country. Pays 20.
No, first of all, you have not brought on record the affidavit, additional affidavit. I say that it is made clear if the additional affidavit is not filed or the petitioner is not represented on the next day, the instant petition shall be dismissed for non-prosecution. You're not interested. What to do?
Immediately start doing it.
Huh?
Immediately,
No, he is not interested. You are not, you are trying your best. Hmm?
I tried to.
Then? Then what should I do?
Alternative land may be provided.
No. You apply. You apply. Who is asking not to apply? Apply for land allotment.
This land I am providing.
No, you cannot get any reserve on reserve forest.
The forest village I will provide.
They cannot. The state government cannot. That is what I said in that judgment. No? The state government even cannot grant an allotment in reserve forest unless they de-reserve. And de-reserve can only be done with the concurrence of the central government.
Forest officer is also here. We have no.
What do you want, Mr. Borgia? Dismissal? The learned counsel for the petitioner submits that he has no instructions from the client for which the additional affidavit could not be filed on record. Taking into account the above, this court grants an additional opportunity to the learned counsel for the petition. Lists the month This is the matter in the month of January 2024.
59.
On next report number 10, 1035.
Which one? Oh, this one, ECA. Then what do you have?
Led by
Mr. Council, I'm telling you, I am not concerned who you are, with whom you are led or not. I don't give any adjournments on the ground of the senior council. You have to argue on that day itself, you wanted to argue. I've asked you to argue. Don't you think so? Show me how the writ petition is maintainable for contractual dues against ACA.
But and another, firstly, this matter has been allotted to bench for the, so it is wrongly listed.
Are you seeing that?
But I have just seen the cover file of it is staffed as bench for.
The learned counsel appearing on behalf of the petitioner, Mr. B.P. Bora, submits that the instant writ petition pertains to bench 4 and not bench 5, the roster which this court is presently taking. Taking into account the above, this court directs the registry to list the matter before the appropriate bench.
Orders.
Yeah. Bye-bye. I'm there. Huh? 89. 89. Okay. What is this? Oh, that matter. It is not finished. Okay. This is the matter before any other bench. None appears on behalf of the petitioner on call. It further reveals that on 14/2/2023, the petitioner was not represented, as well as on 21/7/2023, the petitioner was not represented. Taking into account the above, it seems the petitioner is not interested in the matter for which the petition stands dismissed for non-prosecution.
39.
Yeah. In view of the order passed in a year, the petitioner is directed to take steps upon the response number 3 by way of registered post as usual. Then what happened? Matter is laid before the honorable court, list the matter. Yeah, further notice upon the respondent number 3 has been issued.
We have a respondent number 3.
Oh, thank you.
Fine, Bakalata. Can you post?
Miss so-and-so, your name?
Sigora.
So-and-so appearing on behalf of the newly impleted respondent number 36 for an accommodation of 4 weeks for filing the reply to the contempt application. Just list the matter again on 10th of November 2023. The affidavit be filed by 6th of November 2023.
40.
Oh, service in respect of the respondent numbers are deemed to be complete by the laws in the court by the others are duly. The service being complete leaves the matter for admission immediately after the publication. Oh, why? Oh, Is it? So nothing remains, Mr. Council. Okay. The office note reveals that the service upon all the respondents are complete. Miss Gustav. The records, it appears from the instant, it appears that the instant repetition has been filed challenging the order dated 13/3/2018 passed by the presiding officer, Learned Walk-up Tribunal, Kachar, in Miss W case number 6/2017 in Walk-up Tribunal case number 5/2017. Where is that order?
From Director Director.
Huh? Walk-up Tribunal 5. A perusal of the said order impugned reveals that the application filed by the petitioner seeking injunction was refused. The learned counsel, Miss S. So-and-so, appearing on behalf of the respondent number 616, submits that the said said Walk-up Tribunal case number 5/2017 have already been disposed of by the tribunal, Walk-up Tribunal Kachar Silchar, by a judgment dated 31/12/2019. A copy of the certified copy of the said judgment has been placed on record. From a perusal of the said judgment, it reveals that the suits so filed by the petitioner have been dismissed by the learned tribunal. Considering that the suit have already been dismissed by the judgment dated 31/12/2019, nothing further survives to adjudicate in respect to the non-granting of an injunction by the order dated 13/3/2018. Accordingly, the instant repetition has become infructuous and accordingly enclosed. Give your name. A copy of the said judgment is kept on record and marked with the letter. The certified copy of the judgment, you give a photocopy. Photocopy. Here you go. The photocopy of the judgment is kept on record and marked with the letter.
41.
You were supposed to file your reply. What is urgent? 15/12/2020. 15/12. Yes. Since the basic dispute in the refusal pertains to the claim of the visitor to receive on account of the land it is acquired by the government, I have the view that solution can be sorted out on the basis of the On the petition, appreciate there is urgency in any software. Public instruction, they are not inclined to pass the petition.
In that event, the person is an execution or convolution of DNA. Present, present to the species is called. Because unless the report is placed, we have failed to qualify the ability because by what the recently I have got this COVID today that they are correcting that they have given a wrong ability because they did not correct the record. I have got the COVID today. They are correcting now. My name is there as a Raya. But in the summer one day, they did not show it. In the Shita name is there. So I moved the petition before the additional deputy commissioner. They corrected him kindly. And they have started. And now
You are challenging the entire acquisition proceedings.
No. Now prayer is or not the condition or the crazy compensation. In the prayer meditation now. Because
When was the award passed? Yes, when was the award passed? You are not filing any reply.
because the records they did not correct it.
No. The matter has come today because you were supposed to file affidavit.
No, but they have the positive reports. Last Sunday.
Oh, the record was directed to be produced on 11/1/2021. We are in 2023.
Correct. But
Then you have taken time on 11/1/2021 to file an affidavit. Thereafter, it is not known, the matter has not come up. How do I know whether the deputy commissioner was present on 11/1/2021? I was not even a judge there. Yes.
What has happened here? Why the petitioner is not filing a reply? Because of the categorical statement taken by the affidavit filed by the deputy commissioner himself.
Where?
I have taken that affidavit. So that is filed by this technique.
Yes.
I will be trying to come to.
Covered by dark number so-and-so was acquired in here for construction of Guwahati Medical College Hospital by demand 19 and declaration dated so-and-so. Then the payment of compensation amounting was paid in the first page to Samsul Alam on behalf of Kutumula Alam on Iman and Iman. And the notification dated so-and-so Iman, but subsequently due to non-placement of full compensation of the land of the Iman by the requiring department, later on the requiring department. The award was passed by the collector and the same was approved by the government. Subsequently, the payment of compensation was paid in the year 95 and so and so. Then what remains? Vera? I read it.
Is not a case of the acquired land. The land has been acquired following the procedure provisions of LA 1894. But in this case, the decision number is not a recorded particular object as per record. So the process of tax. Now it is what they know the producing records, what's the matter? 96 page number 76 of my repetition. They have got some clear confusion that brought this evidence without record. What's the page 76 of my repetition?
It was filed on 11/1/2021. What is there to see in the records? Are you denying this? Why should I see the records if you are not denying these statements? They are saying that there has been compliance to the Land Acquisition Act 1894. They say that you are, who are you? What is the name? The petitioner number 3. The compensation has already been paid. Then what remains to be decided now in respect to an acquisition finished in the year 1975?
That is why records are necessary.
For what?
That is the because they have.
Oh, there is only one petitioner. The petitioner, you are a tenant.
Yes, that's 76 medicine. That I am a of the petition.
Page 76. Yeah, show me. Yes. Certified copy of Shita.
That is Moji Ali, and then and my Saidu Rahman, both father and son. And Assamese could be also maybe my lot. Assamese could be a plate number. Yes, next verse. Assamese could be a rare pronoun, Indian number, and right side my lot.
Wait.
Assamese
রায়ত প্রকাৰৰ খতিয়ান নম্বৰ খাজানাৰ পৰিমাণ দখল ৬৬ টকা খাজানা ৩০ টকা ইমান
and right side.
নজিৰুল আলীৰ পিতা ইমান আৰু ছহিদুৰ ৰহমান পিতা ইমান
Yes.
when is this document
They are denying, but this is document now. I have collected the copy from the edition.
no because why I am saying is I don't understand how can where is this Ulubari Gaon?
Near one of Guwahati Medical College.
It's a village.
It was originally registered for the.
No, because this is a document of 1975-86. I think it comes within, what is the moza of that? Guwahati moza, Ulubari. Would Ulubari moza, can there be a Thailand after the, in terms of the 71 Act? How can they, because Assam temporarily settled area does not come within the municipal area.
So this is till today.
No, you have to reply.
That why they accept the policy? Why they accept the policy?
I am not invited my lord secretary to ahead of the.
No, why they
I
accept
can come to pay the 87 of the 87.
why they accept policy records? When they go to party specific order.
Just 1 minute. When did you file the writ petition?
Well, on 30th of December 2019.
Yes,
30th of December 2019.
yes.
And in the affidavit, he says, I am the petitioner number 3. Where there is only one petitioner.
And he was showing us 57 years.
And my lord, there is a power of attorney. He has been given a power of attorney. It is a litigation in dispatch.
Please tell me.
Where? Yes.
Oh, when but it's a week, Alma, young, so. So, we never considered a cycle of one. He is the petitioner of here. Where we have a study of the
Records will show that going on standing met to me or not at the riot. Why they are after the police?
No. They are saying that you are not a riot.
I have shown you lots of these, some of the press 76,
No, show me the Khotian.
the press 76.
Show me the Khotian. This is not the Khotian.
I'm not here. Name of the press 76.
No. This is the copy of the Chita. Where is your Khotian? Show me the Khotian.
We shall pretty much not be now get shut up.
No, because you have opened your eyes after 95. Because 95, all the people got whatever it is.
Long back, but there's suppressed.
You can't be too long back because of the fact that in this acquisition proceeding started in 1975.
Yes, then 19.
And in 1975, what was your age? If in 57 you were just at the best 1975, you would have been 10 years, 12 years,
Then in
and you got a riot in your name.
2 times Sri Lanka declared.
Huh?
In 97 also they have declared descendant. Notification issued in 97 also.
Mr. Soikia, kindly appreciate one thing. In 2019, when you filed the writ petition, your age was shown as 57 years.
Right.
Meaning thereby, when the land acquisition proceedings was initiated under Section 4, that was done in 1975. What was your age then?
That time my father still was there. Then in 97, my name entered.
Your name entered not in 70. This is of the Ulubari Gaon 1975-86.
No, you lost it when you see page number 76.
That is what on top of it, page number 76C. What is your name? It is of 1975-86. Khotian of the Chita.
The name of my name, my father's name and my name. The serial number 1 and 2. Okay. In the service of the officer, name of my father is Mandir Ali, and my name is Shahid.
Show me the Rayati Khotian.
But your mother, that is, the records are called for. That is
Forget
the-
about them. Khutian you will be having.
One of these, this is the Raya, this is the Raya.
They are strictly saying that you are not a Raya.
Now, that is your records are
Now,
called for.
this cannot be a document. If you are given a Khutian, it has to be 326. If it is a Khutian, you are only saying out here as per 10 years possession.
And the kindly see this record issued recently by the district. As a Raya. Because they have suppressive. That is the records were necessary one. And they put.
10 বছৰৰ দখলৰ মতে মঞ্জিৰ আলী পিতা আব্দুল আৰু সৈদুৰ ৰহমান so and so. This is a note pertaining to not the Khutian. Where is the Khutian? You show me.
That is written in the Raya. It's a in the 76. Right side, my lord.
What are these documents?
This document issued by the DC now.
Why?
Because the hearing text, because the Dhammavan they did not enter in name. Now they are entering in my name. Correct, they are correcting the record now.
Of which dag?
326.
326. This is 600, 893.
And I knew that, very knew that. One of the things 326. That is why records were necessary, my lord, because under.
No, records for what? First of all, you show me. Because this document, Mr. Saikia, this document which you are referring to is a document categorically says only that you have a 10-year possession.
Yes,
Nothing more than that. It doesn't say that you are a Khutian holder.
no, that is why possible kindly see, without records in lordship, it is not possible to decide. And records, that is why they put for the specific order. And that order is not complied by the respondent, my lord.
This matter is fixed on 26/9.
Another letter from the DC, my lord.
What are these? This is for dark number 326.
Because that number 6, that number is specifically mentioned in the letter also. I have got it from my client.
Request you to furnish the actual share of land and possession in this paper that is available in market. Mr. Borbuje, there is a simultaneous proceedings. Why it is going on?
This player he is confining himself to November 328 and February 7 of the number 10. He claims himself to be a liar. Now, some power of attorney. Power of attorney is page number 87. Page number 87.
Understood, but why there are two simultaneous proceedings going on?
These are the persons who are the owners. These two are the persons. Page number 87. Alma Alam, then Ibrahima Alam. Yes, they were the Pakaga. And I am a Raya. Now, in the power of attorney, nowhere there is any murder mentioned. That he is the Raya.
But be that as it may, there is a simultaneous proceedings. Why is it going on? In respect to this matter, see these documents, just give it to me. Have a look at these. Why there is a simultaneous proceedings here? No. First, no. Every time it is coming, Mr. Borbuje, kindly don't say because the matter came last on 11/1/2021 and today. And these documents which he is showing are of recent time, I think, because there is one date fixed on 26/9/2023. That is why I am asking why there is a simultaneous proceedings going on and why there is a letter written by the Deputy Commissioner to the Circle Officer in the month of July 2022. Why? When the matters are pending out here.
He is producing a letter today. I am getting instruction. Tomorrow again, he is producing. I am getting instruction. Where are we getting to, madam?
But Mr. Saikia, Mr. Saikia, he has on affidavit said that you are not a right.
Yes. And he will not.
Show something.
Now, what's it? That's not the matter. My lord, that's my lord. Where is the case?
But they are silent regarding the order passed by the High Court on 15th of 2020. Why they fail to produce the records? Because they are keeping the records under lock and key. When several times they did not open the lock.
Oh, Mr. Saikia, you just records which have been called for is no other record other than the acquisition proceedings. There's no other record but other than the acquisition proceedings.
That's why it is necessary for the chief.
We will look into that later on. First of and foremost, whether you are a riot, show me. No, that record will not have a riot. You are going to file your affidavit or not? Or we should be dismissed on the ground of disputed questions of fact
For the ends of justice, you kindly allow me.
to file an affidavit. This court at the request of the learned counsel for the petitioner, had granted 3 weeks time to the petitioner to file an affidavit on 11/1/2021. This court have duly taken note of that in the affidavit filed by the Deputy Commissioner, it has been mentioned that the petitioner herein is not a right or a person interested to be entitled to compensation in respect of the acquisition proceedings. Taking into account the specific stand, this court for the ends of justice grants the petitioner 3 weeks time for filing a reply to the affidavit in opposition filed by the petitioner, filed by the respondent Deputy Commissioner. List the matter again on 29th of November 2020.
I feel that my understanding, punishment copy of the affidavit.
What? You don't have an affidavit?
I have no copy. No copy is punishment. They are insisting, but the copy is not punishment.
Hey, you have stated that I want to file a reply. Why will you say if you don't have the copy?
Kindly, my lord.
Anyways, Mr. Gorgujari gave a copy.
Let them furnish a copy. Order by-
No, it is there. It is there. Yes. Okay, next slide.
35.
Huh?
42 to 45.
Yes. Wait, what are these? Seeing Mr. Borwa out there, I fear again the fancy was that. I have delivered, I have given the judgment.
Separate kind of an affidavit is not supposed to file an affidavit.
Huh?
Petitioner is supposed to file an affidavit. Not item number that Mr. S. Roy has to submit some documents regarding the license.
No affidavit has been received from the petitioners in the connected WPC number 4213/2014. What is this matter about?
If I
Oh, that matter. This is also pending. I remember that day Mr. Roy wanted to get this matter disposed of. Yes, close. I said no, nothing doing. I remember. You have not filed the affidavit. Where is it? Okay, Mr. J. Das, appearing on behalf of the writ petitioner in WPC number 4213/2014 submits that the affidavit as directed by this court has been filed. Taking into account the above, list the matter again on 13th, on 15th of November 2023.
Your lordship, your director, the lordship has directly give some points about this whole matter.
This one?
In all,
You-
this one, I have declared.
No, we'll see when the matter again comes.
Yes.
You Ben Corning and fire.
This is.
Hmm. If it, all the, yeah, is complete. The service is complete. Matter pertains to, you have got it? You have got it? No stay. When do you want it? After vacation?
Sorry, already the 17/3/2021. So the petitioner was granted 3 weeks time to file a reason there. In reply to my original question filed by us.
Whether the service is complete or not. I'm only concerned whether, for whom are you appearing?
That's one number 2, 3 and 4.
Okay, it is okay. Who appears for 5? Huh? Okay. It is service is complete. Service being complete leaves the matter for admission immediately after the vacations.
47.
Yes, service complete. Huh? This court have duly perused the the affidavit of service filed on 10/11/2022. By the petitioner. Taking into account the above, this court deems that the service upon the respondent number 3 is complete. This accordingly lists the matter for admission immediately after the puja vacations. Who are the poor people who is suffering? For what? What is?
There was an accident, madam, 40%, madam.
Okay, to be listed on immediately after the puja vacations on 15th of November 2020.
48 and 49.
Yes. Service complete. And 49,
49, I have been against today itself.
service complete.
Yes. Whether 35% complete, but we may have some action and affidavit also.
You want to file pleadings.
Yes.
Okay.
So after.
The service being complete in both the petitions, matters to be listed for admission in the on 6th of December 2023. In the meantime, the parties may exchange pleadings.
50.
Yes. Yes, Mr. Sharma.
Regarding this matter, regarding petitioner's claim during the inspection, who kept policy money.
No, it's okay, but matter has come up for what? Service has been completed as affected in the law. We mentioned that the service upon the has been completed. The mention has been allowed. Listing on the other. Who is appealing for whom?
I received instructions to make a submission.
Yes, please do.
that the claim of the petitioner was not included. After receiving documents, validated the matter has gone to ombudsman. Ombudsman rejected the then matter has come here, but I have the section 2 stated they are willing to settle. Again, they will settle. In fact, this court may record my sanction. That insurance company will pay the amount. as per the-
When? I think a written instructions,
I have received the impact on bail. I can give you the impact.
we can have it next week. You can just produce the written instructions, then we can. From the perusal of the office notes and the orders of the Lozima court, it reveals that the service upon the respondents are complete. Mr. Argusami, appearing on behalf of the respondent number 2, respondent number 3, 4. Respondent number 4 submits upon instructions that the respondent number 4 is willing to settle the matter with the petitioner. Taking into account the said stand, this court, and the taking into account the above, this court directs the respondent, to place on record the said stand by way of an affidavit, so that the matter could be brought to a logical conclusion. List the matter again on 9th of October. Can you get it? Just the one affidavit. Or we can have it on 9th, 13th of October for admission. Give your name. Yes, who died? 7 died. When? And what are all these applications? So many applications here. One is what? 31343 is delay. 343, the learned counsel appearing on behalf of the petitioner. And instructions not to press the said application. Accordingly, the IA stands closed on withdrawal. Econodio 34 Iman. And this is 331. This is an application for substitution of the legal representatives of the respondent number 7. Respondent number 7, who expired on 18/2/2020, leaving behind the legal representatives. Respondent number 8 is already there. Leaving behind the respondent number 8 and his daughter, Miss Upasana Bharali. Taking into account what is the matter about for striking out somebody's name. In fact, 343 ought to have been allowed. You know, what is the repetition for?
Regarding the previous case against the respondent number 7 to get that property vacated by removing respondent number 7.
Okay. 7 and 8. Taking into account that the respondent number 7 and that the respondent number 8 is the wife of the respondent number 7. This court only substitutes. And the respondent number 7, and she is already there on record. This court only substitutes the daughter of the respondent number 7, Miss Upasana Bharali, who is a resident of Arotipa Plaza, second floor, Chanmari, Guwahati 781007 in the district of Kamrup Metro Assam, as the respondent number in place of the respondent number 7. The registry shall make necessary correction of the records on the basis of the same, of the instant order, and also update the same in the CIS. It will petition issue notice, issue notice upon the newly substituted respondent number 7. As substituted and numbered as respondent number 7 equal. Newly substituted respondent number 7 by registered as well as usual within 7 days from today. List the matter after completion of service upon the newly inserted respondent number 70. I can dispose into a last ultimately to repetition. None appears for the applicant, and further to that, no additional affidavit, and let the matter be listed and make clear if the applicant is not represented as well as any affidavit in the file, this court shall dismiss the affidavit for non-pursuit. What? File. The legal counsel appearing on behalf of the applicant submits that the additional affidavit has been filed. List the matter on for file had filed the additional affidavit today. List the matter again on 11th of October 2023. The registry shall bring on record the said additional affidavit. No. Why?
I decided for the substitution of legal heir.
Why are you filing objections? Whom do you want to bring?
My lord, actually, several petitioners died. So, 7 years, given a chartered case of 15 months.
Then
All of them died during the COVID period when I accepted
Then you want to bring them,
on record.
and the other side has filed objection.
Yes.
Why?
Yes, sir, the delay is not properly explained.
What is the delay? When did the people die? Date of death is one. Are you saying?
No, several days.
Then how can this go to and one person has died in 2016?
Yes, on several dates.
COVID had come.
COVID period of 15/3/2022.
This is of 2016. 23/9/2016. 11/2/2016. 6/6/2019. And you are saying COVID period. Yeah, see, 4/4/2018. COVID period.
No, ma'am, I have given the date of death ma'am.
That is why.
On 9/7/19.
And so COVID had come.
No, madam. I said, man, except 2 and 3, all of them died.
What except 2 and 3? You say these people, all the persons as regard number 4,
Oh, yes, ma'am.
all the persons as regard number 13,
13 years, ma'am.
all the persons in number 34, all the persons in respect to 39, 38.
38 no money. COVID starts with 15/6/2020.
So here it's 6/6/2019, 38.
Oh, yes, sorry, 19.
Then all the persons have died in 42.
Yes, madam.
All the persons at 43. Then only 2.
Yes.
Yeah. Okay, we'll take some other day. It's a serious thing. So why are you filing this requisition in this manner? Tell me. Why? What is this requisition for? So many people
Election order issued by the railway.
eviction. Madam, why you are opposing? Eviction order, what are you doing here? Why are you doing? What are you doing here? You gotta stay.
Yes, some advocates were there, madam. There was conduct.
Madam, we'll do one thing. List the matter on tomorrow. Tomorrow, no, on Thursday, 2 o'clock. We dispose of the matter. And he knows the fate of the application. We dispose it of unnecessary this type of application.
54.
Yes. What is this case again by Fancy Bazaar Municipal Market Dealers? That I know.
We are sitting in an area, madam, inside the new complex, but outside the premise, in their set of area.
And what is he doing?
And they are sitting our outside. They say,
No, he has only 2 shops, no?
oh my God. No.
These people have how many shops?
This completely different.
This is another one.
They have the entire area.
Who? Fancy Bazaar Municipal Market Dealers Association. What was the other one? Where you have only 2 egg vendors.
Fancy Bazaar minor. Here the umbrella association is Fancy Bazaar Market Association.
Market?
Fancy Bazaar Market Dealers Association is a umbrella.
And you are Fancy Bazaar Municipal Market Dealers.
This municipal, I missed. Municipal.
And what was that?
That was also municipal.
Then what is the difference between that?
Because
They were given the mezzanine floor.
no, madam. Here we are completely different. Because there is a building, setback, they have allotted some person, more, I think, food. They're completely different. But in the meantime, in the COVID, some other person has taken over the third party driver, they are not getting. And then thereafter, we have to do this kind of person. Because some of them.
No, but I have given the judgment. I think you may get it out there. But the judgment, one thing, you see, what is their right? Do they get the right under the Vending Act or what?
No, we are.
But as regards that SS road,
No, that is not the different.
no. Because why I'm saying it, you have put the mezzanine floor as a vending zone. If that is a vending zone, what not? Why the others are not?
Because that was vending road, this is for the FSC. There will be sitting for the FSC. But
Understood. But how are you making that portion as a vending zone, not the others?
setback of the building, you allotted the setback of the building only for vending.
No, this is for the overall. Because that is why I'm saying, that is a case where you are mentioning that this mezzanine floor will be a vending zone. And thereby you will be issuing certificate, not license, certificates.
This for only for vending for box and all this.
Huh?
Box and other things for.
I'm not on that, what they went. I'm saying that the moment you are making them as a vending zone under the Street Vendors Act of 2014, they don't have a right unless you issue them the certificate. You have to issue them the certificate. It is only when you issue the certificate, they get a right. And not only that, you, in your certificate, you can't say that, okay, the mezzanine floor is yours. No, you have to allocate a particular area. That's the vending act. And even a particular act, a person may be given for 6 hours or 7 hours, and this 7 hours will be given to another. They don't have a permanent place. As per the vending act, they don't have a permanent place that this is my place. No, because they originally come from street vendors. Huh? Therefore, if you see the street vendors there is a possibility that you may remove them from this and bring them in some other place. Yes. So that is what has also been mentioned in the 2014 Act. So that is them. So there, the GMC has no right. Because here the license has to be given by the town committee. Yes, the amount of money can be taken only by the town vending committee, not by GMC. And there the commissioner of the GMC, as per one affidavit filed by you, becomes the chairman. And there is also a convener also of GMC who becomes something. So these are the persons, that is how the town vending will be. So the license has to be issued, the GMC, so the power of the GMC in the mezzanine flow is out. Huh? This time, forget about that. This I'll take care of it. I'm not saying, I'm saying about that because I'm yet to sign that order. There the GMC has no right. Even the license is not to be here. You are issuing the licenses to them, allotments to them. But that allotment, nothing to be done by the GMC. It has to be done because in 2014 or 13, prior to the 2014, and in view of the Supreme Court judgment, you have already formed 7 sending vending zones, town vending zones. And those 7 town vending zones, one happens to be this. Sure. Yes, Mr. Musam.
In this area, madam, we have been.
After taking up this bench, I'm just moving on that particular building. I'm just thinking how it is.
I understand.
One is the L pattern.
Yes, it's
Madam,
we are also sitting in the Alpatan area.
You are in L pattern.
And they are extremely satisfied in Alpatan area, but they are not sitting in our place. And
No, I passed one judgment in the L pattern thing. L pattern was those persons who, you are which one?
Another one.
Guwahati Tholua Shak-Pasoli Byabsayi Samiti. There is another one na, in the L pattern, fruits. Ha. So they are only into the fruits, which you have not given, and which he is opposing. You are opposing.
I am not opposing because I am allotee of this space as a category 2 fire victim, so that is why.
So you don't want them to sell anything else.
No, they may sell, but not enforcing our space or allotted space because we are
No, not in this case, in that case.
That was, I was not, Polo Kotoki was there, they are selling the same.
No, Polo Kotoki was not there. Another one was there who made a mention. Then I said that one Mr. Bordoloi made a mention, PK Bordoloi. He made a mention, but he didn't know. The other side was somebody else who was appearing later on. So there in that case, that particular, those persons concerned, their concern is, we are selling inside something, and if they sell outside something else in the L pattern, then we do not. L pattern's problem is, you see that there are other street vendors whom the GMC has allowed to sell everything. And my market is bad because I can't sell anything except fruits. Yes. Yes, you are.
Madam, we are a set of traders, madam, about 25 or on the street there. That we have been doing business there, madam. It's 90. And our position there also is already well not accepted by the municipal. There was a case also, we have an order in our favor, my lord. And this is their survey, my lord. If you listen that, 22.
Now, what is he asking here again? Let us know, no, Mr. Rito man, directing another unit to be allotted, to be the allotted of open space in the judgment of Iman in application number.
My lord, in the prayer, my lord, of the repetition, your lordship will kindly speak for us.
So if this order is being passed, you may be evicted.
My lord,
Are you going to be affected?
this case is not sort of, my lord, pointed out. It is that area, my lord, where we are sitting, my lord. My lord, we have not made a party in their petition. We have never made a party, although we were doing business there.
So they are asking, directing and commanding the respondents to initiate a process of eviction of outsider
Yes,
who have been occupying the space allotted for petitioner number 3 to 6.
my lord.
And
outside
others
of the
similarly
party-
who are members of the petition association and then hand over the same. So here the petitioners have been handed inside.
Yes.
And how are you affected?
Madam, they say, madam, the repetitional engineer, they say they are category 2 from fire victims. Category 2 meaning, my lord, I do not know how it came in the deliberations, my lord. They were not having license.
Now, I remember that is the order of Justice Biswas. Category 1 were those people who were having license at the in the year 1989, and those who did not have the license were category 2.
Yes.
Category 1, there was a direction that they have to be rehabilitated, but category 2, the direction was given that they are to consider.
Yeah, to consider. So, my lord, in one way, my lord, we are similarly situated. We also do not have licenses. We are doing business.
You are
there.
category 2.
We have not made parties there, but we didn't, our case is different, man. In 2015, I have a judgment in my favor. So all these things were there, one thing was never clear, man.
They have approached this honorable court and
Municipal
Obtain
is
direction, my lord.
municipal is represented in both the cases.
100% they have got the direction, madam. And accordingly, Mamo is considered, I don't know my lord, but this is the order, madam.
No, but are you affected by these directions? What is he
Yes,
asking
madam,
for?
because I am doing business there. There,
No, they are only asking that those people who are in their possession should be out. These areas have been allotted to them
Yes.
inside. You are not outside.
we are also inside, madam, that list, madam, this is survey of the 2022, madam, so list of unauthorized vendors located at ER. We are continuing there, madam.
No, are these people inside?
Yes, madam.
Are these the petitioner, the applicants are inside there?
Every day, madam.
Because another problem arises with this.
No, it's not effective. Since 90s, madam, we are file affidavit, madam.
We have evicted all
This is
the.
letter line.
Another person you evicted. And they were.
They file lead petition saying unauthorized. Who are, you are sitting direction, eviction against me, you are not making me a party, you are not giving me.
And the order said that they should consider a mechanism for them, my lord. This is the order. So now our issue is. different.
Have you filed your objection
Yes.
in this case? We'll
I
take
said
it
that
up.
we have different class from them. We are a category code, they are a street vendor. So street vendors actually apply to them. We are allowed this, so we should not be disturbed in our state. That is why they have no interest in our.
Show me that order. We'll take it up next week. The order to- Mr. Bora, you are getting sandwiched. Eh?
Depending on all this area.
No, we do not come under the definition of vending act, madam, because if they have, if they that word vending. madam,
No, this order, you are saying,
we are not-
no, it's okay. The petitioner sworn is a registered committee under so and so. The members are mostly nearby village of so and so. They are vegetable vendors that are carrying on the business nearby the western side of Pennsylvania. They used to sell vegetables, bringing from the respective villages in the early morning and continue the trade till noon over the so and so. The respondent filed the affidavit in so and so. Mr. Bora, so and so members of the are vendors carrying on the trade of selling for that purpose, and they used to come in the morning And after completion of trade, they left to the residence situated within a honest manner. They are hiking their livelihood and they have a right to carry out the trade in the order to is also taking necessary action for its allotment of land and to that effect.
It will also come.
then
and it
requesting the
will be-
development development commission of the government.
They find affidavit of-
No, are you the petitioner here?
Maybe applicant.
No, in
Yes,
this.
yes.
So you are vendors, these street vendors.
Not still, man, but we are doing business in that area, man. Ending of the how, man.
You were not inside there.
Yes, sir, inside.
No, they did. This order, then you need to seek a review on this order.
Para three, madam. Para three.
Of this order,
Yes, madam.
the respondent GMC.
File affidavit of opposition. In this state, affidavit of opposition, it is stated that they are running their illegally occupying the vacant land which is setback on the fancy market complex. And the same is to be kept vacant as per building by the members of the committee are unauthorized traders and the GMC did not allow them to run their business around fancy market complex. They were evicted time to time. Initially, there was a practice of collecting scavenging tax from, when we paid tax in 2019, but
From
That
the
is what-
street vendor, that 20 per vendor and per day. But you will be at best, there are more than 7,000 vendors.
so this tax was collected from irrespective of not only those who were on my lot, from the traders who are regularly doing business from their own place, where they are collecting the same tax.
I will
In
now,
19 previous law.
Thursday, 2 o'clock.